I will call to order this pre-meeting, or meeting about the meeting, whatever you want to call it, of the Westland City Council. It's Monday, February 10th, 2025. And we're going to go over the agenda in the pre-meeting. Time to ask questions if you need any information from staff before we get into the regular meeting, if it's feasible for them to track it down. Mayor and council reports. I'm going to pull the community advisory group appointments, if that's okay, just because we have a busy evening and haven't had time to review those with everything going on. And we also still have some applications coming in. So we will do that on the 18th, since that's a special meeting anyway. That's the point. Next week. Got a full agenda tonight. Next is the council priorities. Any questions or comments?
Yes, we're sticking with DEI despite the federal administration.
True. And belonging. Don't forget belonging. Adopt city manager goals. Mr. Williams, do you have any comments on that? Glad to get to this point. We're ready to adopt, and soon enough we'll be in your next performance evaluation.
Can't wait. We should do it monthly. Yeah, I like the extra specificity in this year's version. Just gives us some examples of things that illustrate the goals. So I
want to thank Councilor Bright for taking a stab at going through and helping out with that and sending over a draft to me. I liked it, so we will adopt those if everybody's ready to do so. And then we have the consent agenda, which has a couple of meeting notes and a couple of other items on. Do you have any comments on the ops conference? That's a follow-up from a previous item.
It is. Morgan is here in case you have any questions. If there's anything you need before doing it on the consent agenda, that's why Morgan stayed. Topic we talked about before.
No questions. Good. Thank you.
Should be off the hook, Morgan.
Then the city attorney employment contract amendment is on the agenda as well for the consent. Any questions on that? Okay. We will then move to the business meeting, and I can turn it over to the city manager for your part. Or I can keep going over whatever you want. Usually I turn it over to you for the business meeting.
The public hearing on Ordinance 1757. City Council doesn't do street vacations all that often, but the staff report was pretty clear, I think, about how we got to here, how the application was filed. These folks have been working hard on this one to get you a procedure that is ready to go, and I think any questions you have are better directed at
We've done like 4, 5, or 6 of these, and they've never been this controversial.
No.
Never. Usually there's like just
usually
nobody shows up.
We figured you were ready to level up.
Yeah, we've leveled up. Thank you. Any questions?
I have a particular question. Just what the definition of prejudicing public interest would be.
It's a great question that we can probably talk about more in the actual hearing. I kind of want to avoid deliberating before we're actually in the hearing itself, but it's broad. It's
Yeah, and just to be clear, I'll step aside from the city attorney's seat, and Ashley Dugill will take my place. She's a land use attorney with Barry Elsner, and so I think she can really help streamline that process. Last time there was a little bit of a bump. Josh was going to take my spot and didn't, and we ended up like kind of talking back and forth, and he was in the aisle. So this time I will give him my seat because we don't have the council table that's long enough, and it won't be as choppy as that experience. So
Still went well the last time.
yeah, I think it. Yeah.
And this will go well as too. So okay. Any other questions? I suppose there might be other questions, but we can get into, if they're substantive, we'll get into them during the meeting. That was a good question by Councilor Barnes, and I was thinking about the same thing.
I just spent 3 hours with this agenda.
Do you have a comment? Okay, you're right. Okay, you weren't raising your hand. Anything else on this ordinance, or shall we move to the next ordinance because this council gets things done? We got a lot of ordinances.
Yes, you do. The wild animal feeding was discussed recently in work session. You agreed to advance this to adoption, so that's what we have here. It's not changed from the last version that was discussed. Hopefully this is our last conversation.
I haven't seen any comments come in about this.
I haven't either.
Okay.
Yeah, not this time.
All right.
Not the work session.
Accidentally did that.
Has there been any comments?
No.
None from the squirrel population.
Couple of videos.
No, not that we've seen.
Uh,
Item C is one that you may recall from your joint meeting with the Historic Review Board. We wanted to check in with council on timing of this project and whether you felt that outreach to the Robinwood Neighborhood Association or property owners or whoever might be appropriate before moving forward. But the HRB feels strongly about this. Darren and his staff have been the ones working on it, so he's also here for that.
Well, I feel like I have some questions to ask that could inform my decision on whether or not we wait till the neighborhood's been involved, so I'll wait till the meeting to ask those. It's not, putting anybody on the spot, but it's just.
So you say.
It's kind of what impact is there of having the inventory?
So it would be an inventory that the city could then use, or property owners could use to list properties individually, either locally listed or on the National Register. And if the city wanted to try to pursue a historic district, the inventory would be used to figure out
To
where
identify.
those boundaries would land.
Okay.
Yeah, so this would just be the first step in a multi-step process to list the property.
It was also important, Mr. Manning pointed out that we can't force people to be listed. So they might be identified and they can pursue it, but they can't be forced.
Yeah.
Good point.
okay, well, any other questions on that? Carol, you're our Robinwood Neighborhood Liaison, so we'll be relying on you.
Yeah,
Thank
we just
you,
wanted
thank
to
you.
make sure that if someone starts roaming around Robinwood taking pictures of everybody's houses, that there's some awareness that is going on.
You guys would notice very quickly.
Yeah.
Anything else, or shall we move to item D?
Item D is an update on the Stafford area. It's been a while since we've talked about this as a group in the open session at council, but there are always things happening out there, and we thought it was a good time to provide an update. So there's a little bit of legal information here, and a little bit of planning information, and a little bit of politics information. So something for everyone.
Great.
On this one. I do expect the Hamlet folks may be showing up for this Rick Cook, I think. Lake Oswego and Tualatin have talked about some or all of these things in their recent sessions, so we just want to make sure that everyone's moving along with the same information.
That's great. This was important to me to get this on the agenda because every legislative session, there's bills that come up, and then there's intergovernmental agreements that we have that not all of us would. None of us were on council for, but we talked about Stafford last in like 2021 or 2022, so I wanted to get everybody up to speed going forward on all the status and give a chance to ask questions. So thank you. We'll do that. And I want to thank everybody for their work in preparing for that session and the agenda bill. Any other questions on that, or we can, it's more of a work session topic, but it's part of the business meeting. Then we have city manager report, which I think will hopefully be at 8:10 p.m., but it might be a little bit later. I have a feeling we're in for a 10:20.
Then it'll be even shorter.
We're in for a little bit of a long night tonight, but that's great. Good issues on the agenda. So then we'll adjourn. So with any other questions on this agenda, comments, or we can adjourn for a nice 20-minute break.
Time to get a coffee.
All right, we're adjourned. Thank you, everybody. Are we ready to go, staff? Okay, thank you very much, everybody. Well, I want to welcome everybody to the meeting of the Westland City Council. It's Monday, February 10th, 2025. We have a full house tonight. Thank you all for being here. The first item of business is to do the Pledge of Allegiance, so we will do that quickly. Please rise. Thank you. And next is to approve the agenda.
Thank you, Mayor. I move to approve the agenda, removing agenda item 4A, the appointments for community advisory groups to a future meeting, and leaving the rest of the agenda the same for the February 10th, 2025 Westland City Council meeting.
Is there a second?
Yes, second.
Okay, it's been moved and seconded to approve the agenda for the Monday, February 10th, 2025 City Council meeting, removing item 4A, Community Advisory Group appointments. Any discussion? We will make those appointments next week on the 18th. Seeing none, call the roll, please.
Counselor Bonington?
Yes.
Counselor Reich?
Yes.
Council President Baumgartner?
Yes.
Counselor Groner?
Yes.
Mayor Bielostowski?
Yes, thank you. So the agenda is approved, and that takes us to public comment, which is for items not on the agenda tonight. So if you're here for the vacation hearing, we'll take your comment in just a little bit during the public hearing. Some folks have signed up to talk about other matters tonight, so we will welcome those few folks up one by one.
Michael Taylor?
Welcome. Just make sure your green light's on there, and you have up to 3 minutes. State your name and city residence for the record, please.
Sure. Michael Taylor, you need the address?
No, just your
Okay.
city.
Michael, will you please pull it close to you, like right in front of your mouth? Like
Okay.
Pop can apart.
So this applies to everyone speaking tonight. If you can get the mic real close to your mouth, that would be helpful and help pick up the sound for the room and also for our recording. Thank you.
Okay, thank you. I had the city clerk give you one page, and I have no complaints. I want to give you a perspective, though. The bond issues that the school district has outstanding over the next 25 years between principal and interest is $624 million. Okay? You have that in front of you. That's from their last audit. The page number's on there. So these are their figures. So when you look at what you have to do as a council, whether it's aquatic center, maintenance, whatever ball fields, parks, please be in mind that us taxpayers are the only source for those dollars when you float those bond issues. And right now, the school district, we're on the hook for $25 million on average per year to the school district bonds. So all I'm asking is continue to do a good job and keep that perspective of the taxpayer in your considerations. Thank you.
Thank you. And thank you for providing the figures as well.
Amelia Chapin?
Hi there, welcome. Just state your name and city residence for the record, please. You have up to 3 minutes.
My name is Amelia Chapin. I live in West Lynn. I am a 16-year-old student at West Lynn High School, and I'm working on getting my driver's license. I never noticed before, but now I see that some of our streets are in bad shape. My grandpa is teaching me how to drive, and he lives on Hill House Drive in the Willamette area. That street was developed approximately 55 years ago, and there are 25 houses on that street, and all of those people pay property taxes. My grandpa pays over $11,000 per year. However, the street has extremely broken pavement and some deep dips. The city put some patches on it throughout the years, so it started to look like a quilt. And I don't think that's fair for tax-paying people to live in those conditions that remind of a third world country. Thank you for your time. I hope you will be able to do something about it. I would like my comment to be entered into the city records.
Thank you.
Dean, sir?
Welcome back, Dean. Just to state your name and city residence, you have up to 3 minutes, sir.
Seat is still warm. Dean Sir, West Lynn.
Two things I wanted to talk about tonight. First was an affirmation and a reminder with regard to tolling. I know that's one of your city goals for this year is to continue the discussion and the opposition to tolling. I'm the chief petitioner for IP 31, which is the Vote Before Tolls initiative, which is active and progressing. So I look forward to that conversation. I'm also the president of Friends of Oppenlander, a 501c3, and we appreciate that you have scheduled a public meeting for discussion about Oppenlander for next Tuesday, I guess it is, right, the 18th. It's not listed correctly on the city's website yet, though, so if you can get that fixed, it's called a work session. It doesn't say anything about Oppenlander. Under the suggested agenda, you included a number of things, obviously an update on the status, but also funding. You talked about, you collectively spoke about a bond measure, perhaps purchasing all or half of the property using the current bond. So we're talking about a bond measure, new bond measure. You also mentioned that Friends of Oppenlander, the public-private partnership, will be making a presentation about how we can help support some private funding for that. But I'd also like to suggest that part of that agenda include consideration of the sale of the Parker Road site. It's a 7-acre site that is undeveloped and has been undeveloped since the city acquired it. That property could be sold at developer prices. Again, about 7 acres. Oppenlander's about 10 acres. The school district is charging us developer prices. We could sell Parker for that. And there's probably room to include the community recreation center on that site and still retain the ball fields on Oppenlander. So something that we'll be talking about next week. So I look forward to that and just thank you for setting aside that time to have an in-depth conversation with the community. Thank you.
Thank you.
Anthony Bracco?
Welcome back, Tony. How are you? Go state your name, city residence, and are you speaking on behalf of the neighborhood or just yourself today? You want
Robinwood neighborhood. So Anthony Bracco, Vice President of the Robinwood Neighborhood Association. First of all, I would like to thank the council for everything they've always done for us. And second, I'd like to say that we are purchased an owl, so now we are in compliance with the meeting ordinances. So I wanted to let you know that. And third, we would like to invite a city councilor to attend possibly. Now, I know the female counselors have always been very well represented there, but perhaps maybe a male counselor or mayor would like to attend one of our neighborhood meetings tomorrow night. That would be greatly appreciated. And then also perhaps later in the evening, I would like to speak upon the issue of the new ordinance being passed about feeding wildlife. That's everything. Thank you guys so very much. Have a great evening.
Thank you.
Larry Reed?
Okay, we'll take your comment during the public hearing just so you can be part of the record for that. Thank you.
RJ Cook?
I think he wants to speak on Stafford. Is that, or just a little bit later in the agenda, but we could take his comment now if we'd like.
RJ, can you hear us?
Yeah, I think I just clicked in there. Do you have me?
Yep, we
Okay.
can hear you. If we could maybe turn the volume up a little bit in the room, if that's possible. But Mr. Cook, are you here to speak generally, or would you like to speak on the Stafford item on the agenda later?
I will let you handle the other piece to that. I just real generally want to give you a quick update about Stafford Road and the construction.
Okay, go ahead.
Yeah, just like Rick Cook, former Stafford Hamlet Chair, longtime resident, starting in June will be year 125 of the Cook farm there on the corner of Rosemont and Stafford. So I've been around a little bit and seen lots of stuff. Most of it we like. Currently, we have, I'm sure if anybody has gone down Rosemont and Stafford recently, you've enjoyed the chance to stop and enjoy the view that you get for 10 to 15 minutes as the traffic goes by. Currently, it's the Lloyd Clark company that's putting in the new gas line all the way down Johnson Road. They'll be here at least for the month, if not longer. The fiber optics company was in 2 weeks ago, which some of you probably lost your cable because they hit a line there. So that little thing. And just one little quick comment was, I was talking with Rich Fiala, and he said, yeah, there's probably 2.7 billion reasons we could talk about the development in the area, but we'll leave that up to you guys tonight. And just want to thank you for the support for the area, and really love to see some agricultural development money going in instead of just housing and industry and that stuff. So with that, I'll leave it at that. And once again, thank you for our partnerships over the year, and good luck.
Thank you, Mr. Cook.
That is all.
Everybody for your comments tonight. General matters, we will move to mayor and council reports. The first item is reports from community advisory groups or city business. Start with Councilor Bright.
I attended Career Day at Rosemont Ridge. That was a lot of fun. Some other counselors were there as well, and had an opportunity to talk with a lot of eighth graders, something that I think they got a lot out of. I also enjoyed speaking with them and would love to see additional career days at the high school as people approach kind of ending their public school careers. I also attended on Wednesday evening the quasi-judicial training and with the Planning Commission and the Historic Review Board, and it was very, very good training, reminding us of our duties and obligations when we are in those quasi-judicial hearings. Thank you.
Thank you. Council President Baumgartner, go ahead.
Thank you. In the interest of time, I will just say ditto to everything that Councilor Bright just said.
I will report that on Wednesday, I went down to Salem for another legislative meeting, and I had the chance to meet with Bruce Starr, who's the vice chair of the Joint Transportation Committee, and Senate President Rob Wagner, who's our senator, and continuing to talk about tolling. I don't know if Dean's still here. And continue to talk about tolling, pushing back against that, and concerns with Highway 43 and trying to get some state funding for that road, and just checking in during the legislative session. So we're advocating, we're at the table. That's my report, keeping it brief. Councilor Groner. Thank you. Councilor Bonington.
I was also at the career day, but I understand some of you are setting up tours as well, but I got to see historic City Hall last Wednesday, which is nearly complete. And I was really actually pleasantly surprised with how it's turned out. It is a very warm and welcoming building. I think it'll be pretty neat.
Awesome. We look forward to seeing it as council at some point. And do we know when that might open up? Any update on the opening of historic City Hall?
Well, for the folks in the room that don't know, after the rehabilitation is done, the building is going to be turned over to a local nonprofit, the Willamette Falls and Landings Area Heritage Coalition, and they will be taking over the building as of probably springtime, and it will probably take them some time. They're still in a fundraising mode in order to get the building where they need it to be to operate as the Museum and Cultural Center. I have heard that it may not be open to the public until 2026 as an operating center. But we will probably be holding events in there and maybe even some tours to show people around.
Awesome. Thanks for the on-the-spot update there. Well, thanks everybody for your reports, and we will move on to item B, which is adopting the City Council's 2025 to 2027 City Council priorities. And I want to thank the city manager and staff for working with us to get this document to the point of adoption. Would you like to say any comments about it before we vote?
If you would like me to, Mr. Mayor, I'd
Sure.
be happy to. Just where these come from, originally, council held a all-day retreat in this room on January 4th and worked to define priorities, not just for 2025, but also for our upcoming budget cycle. We do 2-year budgeting in West Lynn, and so the council was looking out to the end of that budget, which is in 2027. So that's why these goals and priorities are listed as 2025 to 2027. You reviewed them at a work session last week, and ask that we bring them forward to you for adoption. Really what these are is how would the city council like to spend its time and energy? What projects are of importance to you to be personally involved in or involved in as a group, either outside of this room or inside this room? So we use it for identifying items for council agendas and also things that, that you are looking for extra updates for and things that you're also willing to lend your influence to, both here in Salem, at the Metro Council Chambers, Calcamas County. And so it's a good solid list of about 9 items. I think it's 9, covering a range of options, and it really sends a great message to the community and other local governments as to what it is that you're interested in seeing done in your time on council.
Thank you. Good overview. Any comments or questions, suggestions? Councilor Bright.
I really appreciate the way this is set up, and I also appreciate the introductory language where we can remind everybody that this is a living document and we will update it as need be. And I appreciate that staff will be bringing forward updates to our progress so we can celebrate some of our wins.
So I'm glad we're getting these adopted earlier in the year this year. It's good to see. City Council sometimes works on weekends. We had an all-day retreat on January 4th to get these to adoption. So with that, I'll entertain a motion.
Thank you, Mayor. I move to adopt the City Council 2025 to 2027 priorities.
Second.
Okay, it's been moved and seconded to adopt the City Council 2025 to 2027 priorities. Discussion? Seeing none, go ahead and call the roll.
Counselor Bright,
Yes.
Council President Baumgartner, Councilor Groner,
Yes.
Councilor Bonington,
Yes.
Mayor Bielostowski.
Yes. Thank you. So the priorities unanimously adopted. With that, we'll move to the final mayor and council report item, which is important one, adopting the city manager's goals. So we have those on the agenda. Those were prepared by myself in consultation with City Manager Williams, and then Councilor Bright put in some good suggestions as well, and they're here for the council's review and hopefully potential adoption for the year. Any comment from yourself, City Manager, or do you glad to have you on board and have your goals ready for the year?
Thank you. Yeah, I think it's important for not only our relationship, but for the community to know what it is that you think is important for me to be doing as the head of the organization. One thing that is, I think, obvious when you read these goals is working with the council and the community is a big part of it. There are 140 people in this organization that do everything from traffic stops to repairing sewer lines, all that other work. It's taken as a given in these goals that all of that work has to proceed on time and on budget and in accordance with your expectations and community expectations. These goals really spell out what it is that you want me to be spending my time on. And it's incredibly helpful for me to know that so that I can work to achieve what it is you're looking for. And I appreciate your consideration of these. They're set up with just 5 broad goals and maybe 5 or 6 examples of how each one is to be implemented. Just as with your own priorities, these can be changed throughout the course of the year to react to whatever is new things come up, but it does give us all a blueprint to be working from. And as I've said before many times, I appreciate this job very much. It's an honor, and I looking forward to working on all of these things that are in here.
Thank you, sir. Someone like to make a motion?
Thank you, Mayor. I move to adopt the City Council's goals for the city manager, John Williams, as posted.
Second.
Has been moved and seconded to adopt the council's goals for city manager John Williams as posted. Any discussion? None, go ahead and call the roll, please.
Council President Baumgartner,
Yes.
Councilor Groner,
Yes.
Councilor Bonington,
Yes.
Councilor Bright,
Yes.
Mayor Bielostowski.
Yes. So the City manager's goals are unanimously adopted. Moving right along on the agenda to the consent agenda, which has three items on it. Some meeting minutes, the Public Works Operations Center Complex Construction Owners Representative Contract, and an amendment to the city attorney's contract. So I always ask first, is there any objection to a matter on the consent agenda that we have to pull off and discuss? Seeing no objection, so I would entertain a motion to approve the consent agenda.
Thank you, Mayor. I move to approve the consent agenda for the February 10th, 2025 Westland City Council meeting, which includes the January 6th and 13th, 2025 meeting minutes, fixing the January 6th Scribner's error, changing Mayor Bialostowski's vote from voting to abstaining on MIP-24-02 variance 2405. 2830 Coeur d'Alene, the Public Works Operations Complex Construction Owners Representative Contract and City Attorney Employment Contract Amendment.
Second.
Okay, it's been moved and seconded to approve the consent agenda for the February 10th, 2025 Westland City Council meeting, which includes January 6th and 13th, 2025 meeting minutes, fixing the January 6th Scribner's error, changing Mayor Bialostowski from voting to abstaining on MIP 2402 VAR 2405 at 2830 Coeur d'Alene Drive, the Public Works Operations Complex Construction Owners Representative Contract, and the City Attorney Employment Contract Amendment. Reading as fast as I can tonight while still being legible. Thank you. Go ahead and call the roll, please.
Counselor Groner,
Yes.
Counselor Bonington,
Yes.
Counselor Bright,
Yes.
Council President Baumgartner,
Yes.
Mayor Bialostowski.
Yes. Thank you. So the consent agenda is approved. Thanks for the work bringing those items before us. Exciting to get the Operations Center contract approved. Thanks, Kathy, for the meeting notes as well. Let's see. Well, that takes us on the agenda to the business meeting. And the first item, I think, is what a lot of folks are here for tonight. This is the Agenda Bill 2025 02-1004, which is the public hearing for Ordinance 1757 relating to vacating a portion of the 5th Street and 4th Avenue rights of way. Bit of staff transition here as we move in. So City Manager Williams, would you like to introduce the topic before we
I think
get
we'll
going?
just go right into the script, which you
Okay.
have right at your desk.
I just was dropped off to me. I'm reading. I didn't even see it come in. Thank you. Tonight, we are holding a public hearing regarding application number VAC-24-01, a petition to vacate a portion of rights of way on 5th Street and 4th Avenue in West Lynn. This is a quasi-judicial decision. Unlike in legislative hearings where personal opinion may come into play, quasi-judicial rulings must be grounded in the relevant code and law. The hearing will proceed as follows. After the preliminary legal matters covered by the city attorney, staff will make a presentation followed by the applicant. Then there will be an opportunity at that time for public comment regarding the petition. Finally, there will be time for rebuttal by the applicant. The applicant will have 20 minutes initially plus 10 minutes for rebuttal. Any members of the audience that wish to speak must complete a sign-in/testimony form, which is available on the desk over there, and I saw a lot of you did already, and turn it into staff in order to testify and make sure you're part of the record. Councilors may ask questions of the applicant, staff, or anyone else who testifies, and I will now call to order the public hearing, and I will now ask our legal counsel from Barry Elsner to cover the preliminary legal matters.
Thank you, Mayor. The applicant has the burden of proving that the petition is consistent with the provisions of ORS 271080 through 271160. The criteria that apply to this decision are listed in the staff report. These are the criteria that the City Council must use in reaching a decision. As the City Council is sitting quasi-judicially, any testimony, argument, or evidence that speakers give the Council must be directed at the applicable criteria or other criteria in the comprehensive plan or other land use regulations that you believe apply to the decision. Please describe how your comments relate to the criteria. If your testimony would be repetitious, but you would like the opportunity to appeal the decision, you must sign the sign-in/testimony form. Only those who have appeared before the City Council in person or in writing will have standing to appeal this item to the Land Use Board of Appeals. Failure to raise an issue accompanied by statements or evidence sufficient to allow the council and the parties an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals based on that issue. Prior to the conclusion of the first public hearing on an application, the applicant or anyone who takes part in the hearing may request a continuance or ask that the record be left open to present additional information. If there is such a request, the council will either continue the public hearing on a date certain or leave the record open for at least 7 days for additional written evidence, argument, or testimony. The failure of the applicant to raise constitutional or other issues related to proposed conditions of approval with sufficient specificity to allow the city or its designee to respond to the issue precludes an action for damages in circuit court. Now, I ask the members of the City Council to disclose any ex parte contacts, conflicts of interest, or bias, including any site visits. Please indicate the nature and extent of the ex parte contact, bias, or conflicts of interest, and indicate whether you intend to participate in or abstain from the hearing. So, do any members of the City Council wish to declare a potential or actual conflict of interest or bias? Nope. Okay.
The record should reflect none. Thank you.
None. Do any members of the City Council wish to report any site visits or ex parte contacts?
So President Baumgartner, you have the floor.
Thank you, Mayor. And yes, I have been to the site. And so I know where it is and have seen it. And I have had no ex parte contacts. Thank you.
Great.
I will also disclose a site visit probably a year ago, the site, for the record. Councilor Wright.
And the same here, I have walked in the area and have been familiar with it, but no ex parte contact.
Great. And you all feel that you are in a position where you can make a decision regardless of that site visit? Yep.
Yes.
Okay. All right. Does any member of the audience wish to challenge the jurisdiction of the City Council to hear this matter? Seeing any, so then, Mayor, that concludes the legal matters. Oh, no, I apologize. Does any member of the
One
audience
more.
wish to challenge the impartiality of any member of the council? Okay, seeing none, that concludes the legal matters.
We will proceed to the staff presentation, followed by the applicant's presentation. Mr. Weiss, go ahead.
Good evening, Mayor, councilors. Darren Wise, Planning Manager, for the record. So I've got a brief presentation here that will walk through the petition to vacate 3 small pieces of right-of-way down in the Willamette neighborhood. All right, so council's public hearing materials for tonight, you had an agenda bill with some background information and a staff recommendation. There were 2 attachments to the agenda bill. The first attachment being Ordinance 1757, which would vacate a portion of the 5th Street and 4th Avenue rights-of-way. And then attachment 2 was the staff report and findings for this petition for a vacation. There was also a public comment memo that was sent out this afternoon. We received 4 public comments prior to the deadline of noon to submit comments. We actually did receive 4 additional comments after the deadline, but those are not part of the record. So the petitioners for this proposed right-of-way vacation are Forward Vision Development LLC /E3 Design Concepts LLC, SDG SDG-2 LLC. SDG-2 LLC is the actual owner of the properties down there in the Willamette neighborhood. The petition is to vacate just over 16,000 square feet of Fifth Street right-of-way. That is basically going south from Fifth Avenue. You can see it in the map there. The aerial photo would be the center vacation going south from Fifth Avenue down to the Fourth Avenue right-of-way that is also being proposed to be vacated. There's almost 12,000 square feet of Fourth Avenue right-of-way, which we're calling west, which is the left side of the aerial photo there outlined in red. And again, this is just a small piece of right-of-way that just dead ends into the wetland on the property. And then the Fourth Avenue east right-of-way, which is on the right side of the aerial photo. And again, it connects to 4th Street and over to the unimproved right-of-way of 5th Street, which is also being proposed to be vacated. So again, all of these pieces of right-of-way are currently located within a local wetland that's identified on the city's local wetland inventory within the floodplain and within habitat conservation areas.
You're saying all of that red that we're seeing right there is part of the wetland?
That's correct. Those three red polygons, yes, are the rights of way that are intended or petitioned to be vacated, and they're all running through the wetland.
Thank you for the clarification.
So I've got a couple of maps here to zoom in a little bit. So again, this is showing the local wetland inventory. So it's sort of faded out. Most of the property north of the old Blue Heron settling pond is considered a local wetland inventory and has a number of regulations surrounding it to limit development or prohibit development. And again, these rights of ways run through it, and the city has no intention of building a road or running utilities through the wetland area. So the right of way is not needed for those purposes. Same map, just with the habitat conservation areas overlaid on the map instead of the wetlands. As you can see, there's a lot of prioritized habitat in the area. And again, the rights of way run through those prioritized habitat areas.
Do you mind letting us know what the colors correspond with?
Yes, so the reddish color is the high value habitat. Sort of the darker mustard color is the medium, and the light yellow is the low value. And then the sort of the purplish color is the no value habitat. It's typically surrounding streets or other improvements.
Thank you.
Sure, I will do my best. And then this is the last map I've got showing the 100-year floodplain or the special flood hazard area. And again, you can see it covers the majority of the property, including covering all of the three portions of the rights of way petition for vacation. So the approval criteria for a right-of-way vacation or street vacation is found in Oregon Revised Statute 271. Specifically, 271-0802 requires 100% of abutting property owners to sign off on the petition. The property owner, SDG-2 LLC, is the abutting property owner for all three proposals. They signed a notarized, have a notarized signature in the packet agreeing to this petition. And then the second component of the petition property owner consent criteria is 2/3 of the property owners within the affected area have to sign off on the petition. So again, the 5th Street.
Could you define what the affected area is, please?
Yeah, so the affected area, it's in the staff report. You can read it word for word, but essentially it's 200 feet laterally from the portion of the right-of-way intended to be vacated, or until you meet the next street if it's less than 200 feet, and then 400 feet extending out from the end of the proposed right-of-way. So that's the affected area. So you count all of the property within the affected area, and then you need 2/3 of the affected property owner signatures. So the Fifth Street right-of-way proposed for vacation, again, it starts on the north at Fifth Avenue and goes south down to that Fourth Avenue right-of-way that's intended to be, or petitioned to be vacated also. 71.7% of property owners in the affected area, which again is the petitioner SDG-2 LLC. They own enough land to meet that requirement. Same for Fourth Avenue West and Fourth Avenue East. So the amount of property owned internal to the site was enough to meet that 2/3 requirement. The next component of approval criteria, so ORS 271110, requires a notice to be published in a newspaper once each week for two consecutive weeks. Notice was posted in the tidings on January 22nd and January 29th. It also requires signs to be posted at each end of the section of right-of-way proposed to be vacated. In this case, we could only post on one end because the other end is within a pretty dense wetland, so we didn't go boating out there to post the sign. So we posted the signs on January 23rd of this year. And the other component of that approval criteria is that the first publication in the paper and the signs have to be posted at least 14 days prior to the hearing. So that means the first tidings publication was 19 days before the hearing, and the signs posted 18 days prior to the hearing. So those criteria were met. And then the final approval criteria is whether or not the public interest is prejudiced. This is ORS 271120. Some information for council to consider. The rights of way are currently not used. They're vacant. There's no development within them. Again, they cross wetlands and sensitive areas. So the city doesn't have any plan to make improvements to those rights of way. Even if the vacation were to pass, all properties in the area would still have continued access to public rights of way for access to their property. There's a 7th Street, which runs down to the south and connects to where the 4th Avenue West right-of-way is intended to be vacated. 5 homes take access from 7th Street, but this vacation would not impact their ability to access their properties. Again, there's no transportation or utility plans that would need to use the rights of way at any point in the future. And the rights of way are primarily contained within that protected wetland, which prohibits development. And again, the habitat areas and the floodplain add additional regulations onto the area. In the private ownership, if the vacation was approved and the rights of way went into private ownership, the land would still remain subject to the city's environmental review standards. So just because you're vacating the right of way doesn't mean they can develop on the property. They would still be subject to the wetland regulations, water resource area regulations, floodplain regulations, and Willamette River Greenway regulations. And then the second component of that is written objections. So again, 4 letters were received prior to the noon deadline. They were sent to council as part of a memo packet this afternoon. And all of them opposed the petition for various reasons. And I'm sure you'll hear about that during public comment. So here are the sketches that go along with the legal descriptions for the 3 portions. Again, on the left of the screen is that 4th Avenue West. It just comes from 7th Street and dead ends in the wetland. No intention of making any improvements there or connectivity, put any potential connectivity because it just dead ends. The image in the center is that Fifth Street right of way that comes down from Fifth Avenue to the south. Again, it runs right into the wetland. And then the image on the right is the Fourth Avenue east property that basically goes from that Fifth Street piece over to Fourth Avenue and stops at Fourth Avenue. So at that point, I will entertain any questions from council.
Excuse me, any questions of planning manager? Is there another opportunity to ask you questions later in the meeting? Or is this the only time?
No, after the presentations and comments are provided, you can ask me questions after, before you close the public hearing.
Okay, just for that clarification, thank you. Council President Baumgartner has a question.
Thank you, Mayor, and thank you, Planning Director Wise, for your presentation. I am I think, what's caused me to have the most pause is I guess the lack of requirement for having any kind of communication as far as approval from property owners. And I understand the criteria, but I see their names listed here. I see 15 property owners with listed on the consent to vacate petition. If they're not necessary, why are they listed on the petition? I mean, there's no signature, it's just blank, but I'm just curious.
I would save that question for the applicant,
Okay.
The petitioner, when they come up, they might be able to answer why they were included in the packet.
I was just speaking mostly from like a legal standpoint. So am I understanding that it wasn't necessary to?
That's correct. You have to,
Legally?
correct. You have to have 2/3 of the properties in that affected area sign off on the right of way. And again, the petitioner SDG-2 LLC had more than 2/3 of the property in that affected area, so they did not need to acquire signatures from anyone else.
So they could have sought and potentially obtained approval from some of these property owners, and I will ask them too, but they didn't need to. Is that what I'm understanding?
That is correct.
Okay,
Yep.
thank you.
Not at this time. We'll have time for public comment in just a little bit. Well, so thank you. I appreciate that. But when you come up to speak later, you can point that out if you don't mind. We can't have folks from the audience raising their hands to comment sorry, but have to have some rules. Thank you. Councilor Bonington.
I understand the distinction between owning property and having it be a right of way, but is there any sort of proposed compensation for us doing this, or would we just be giving it and that's it, should it pass?
There is a fee associated with this petition. So the petitioner paid the fee as set by City Council.
That's the $6,000 application fee, or is there a separate one?
That is correct. And then they will be required to pay the recording fees at the county if it's approved.
So essentially just fees, but no specific compensation outside of that then?
The property, if the property were to be vacated, it would go back on the tax roll. So that would be the other compensation, I guess.
Thank you.
I had a question about the Parks Master Plan and the connection of that to this issue. You mentioned there was no utility or transportation kind of purpose for the city, but do you foresee a need for it to be part of related to the Parks Master Plan? I did see that in some comments and read them and started to think about that.
So the comments that came in today, so I didn't have a chance to do a deep dive into the Parks Master Plan, but I did peruse it and I did not see anything that mentioned these specific
three areas being part of the Parks Master Plan. So you might want to ask the commenters where that came from.
Thank you.
If I can add to that note as well.
Go ahead.
To be able to create a park in that area that's currently right of way, the city would have to do its own vacation process. So you can't build a park on public right of way. You would have to first vacate the property and then declare it a public park and develop it into a public park.
Interesting. Thank you. Do you have a follow-up, Kevin? Go ahead.
I was just wondering if we're all clear about the distinction between right of way and actually owning a property.
I think so.
Okay.
If it comes up later, you can re-explain it again.
Okay.
Thank you. Any other questions? Councilor Bright, Councilor Groner, haven't heard much from you. Anything for Darren so far? Okay. Well, with that, we can continue on in the process. Let me go back to my guide here. We will proceed to the applicant's presentation. And we'll get the clock up, and these time regulations are set by our rules. Is that correct?
For the applicant's
Yes.
time limit? I
Yeah.
believe so.
Okay, I'm just asking, just because I know some folks, public commenters only get a certain amount of time. Applicant gets a little bit more time.
Yes.
That's just how the rules work. So we'll try to be as flexible as we can with public comment time tonight, as we know we've got a lot of speakers, but want to hear from everybody. And at this time, we'll get 20 minutes up on the clock for the applicant, and I'll turn it over to applicants. If you could just introduce yourselves for the record, please, for the council, that'd be great.
Sure, Mayor. Good evening, Mayor and councilors. My name is Garrett Stevenson. I'm legal counsel for the applicant. With me tonight is Mercedes Sarah with 3J Consulting, and she's going to give you an overview of the application materials, the purpose for the vacation, and provide hopefully a quick and dirty outline of the application. So you've got a working knowledge of it if you didn't have a chance to look at it recently. And then I'm going to go ahead and make some comments after she's done with her presentation. And I think there's some questions from Councilor Baumgardner and the mayor and Councilor Bonington that I'd like to address, and hopefully that will be helpful.
Great. Hello, my name is Mercedes Sarah from 3J Consulting. Just want to give you a quick overview of the project and the process and where we are. So as stated, we are looking to vacate portions of 4th Avenue, both east and west on the property, as well as a portion of 5th Street that comes down from the north. These areas are primarily located in habitat areas. A large wetland is on the site, and then there is a portion of 5th Street that is outside of that high value habitat as well. These areas are not identified on the city's adopted plans for access. They don't provide extensions of services to the surrounding properties. And in fact, we have consolidated the property into one tax lot that we'll be recording so that they don't provide access to any individual tax lots that would be now, if vacated, unable to be accessed. They don't impede any future development of neighboring properties, as they are internal to the site only, and they are not needed for connectivity. Based on the city's code requirements, these areas are protected habitat, and we would be subject to any habitat requirements under any future development of the site, including Chapter 32. Just want to make sure I touch on all my notes here. And as it was mentioned, it is not identified on the Parks Master Plan, as to our knowledge, as an area that would be park or park access through there.
Thanks,
Thank you.
Mercedes. I want to make a few comments, primarily due to the last minute written testimony that I saw today. And I want to frame these as being responsive to the comments that I saw in writing and the comments that I believe you'll hear orally today. But I also want to try to ground the discussion in what we're actually trying to do here. A lot of the comments that I saw, and I did try to skim them before I came here, were concerned about future development of the broader area. That is not what's before the council tonight. What's before the council tonight is a right-of-way vacation of just over 1 acre worth of roads that have been platted since 1908 and have never been used for transportation of any kind. And with that, I want to turn to what is a right-of-way vacation really for? And I'm glad to hear that you recently had your quasi-judicial training, because that's always a fun thing to wrap your mind around when we're talking about land use cases. But this is not a land use case. This is a case about whether or not the city needs these roads for transportation purposes. That is the intent of ORS 271-080 and the statutes and sections that follow. And what that statute's intended to do is to address situations like this, where somebody has platted a right-of-way and it has been there for a long time and is no longer needed for anybody to use for access. There are 3 criteria. And one of the things I want to point out, and just make sure it's clear on the record, these are the 3 criteria. The city does not have its own right-of-way vacation ordinance, so we go to what the state imposes in Chapter 271. It does not require a finding that the proposed vacation is consistent with the comprehensive plan. It does not require a finding that it's consistent with any zoning ordinance. This is purely about access and transportation. So the first thing it requires is the consent of the owners. And it might have been Councilor Baumgartner that asked, why is there a big list of people within the affected area that haven't signed? Well, that's simply because we have to identify all of the owners in this procedure that are within that 200 feet of the area to be vacated. And that's what we did. And where you see a signature is where those folks have consented. So that's why some folks did not consent. You have not 100% approval, but we don't need 100% approval. The statute's very clear that we only need, I believe, 2/3 majority. The second thing I want to talk about is the question of public interest. One of the comments I saw talked about this and asserted that this is not in the public interest. We're not required to show that this is in the public interest. What we're required to show is whether the public interest will be prejudiced. That is a meaningful difference, because again, what this statute requires us to show is that nobody needs this right away for access. What this question is getting at is whether the city will be out of pocket and whether surrounding landowners will be out of pocket if the city gives up these rights of way. Obviously, the answer to that question is no, because the city has had this for more than 100 years. It's never sought to do anything with it. You heard from your planning manager that there's no current proposal to build out these rights of ways or even to use them for utility purposes. So it's going to be hard, I think, and understandably so, to decouple this with the question that you're going to be confronted with from the folks who sit behind me, which is whether this area should be developed. And they're just simply different questions. Now, I expect that there will be a proposal for development in front of you that will go through land use ordinances that get at all the things that the city intends us to talk about when we go in and do development. Things like the comp plan, the zoning code, the parks master plan, the wetland protections, both local, regional, and state. But that's not what's at issue tonight. So let's look at the question of public interest from the perspective of what this statute really asks us to do. And so I did a little bit of research, and it was somewhat interesting, but this right-of-way was originally platted in 1908 as part of the Willamette and Tualatin tracts. And the plat actually says what this is supposed to be used for. And it says it should be used, the use of all streets shall be dedicated to the public. So you'll note there that they were talking about the use being for streets. They are not talking about the use being for parks, for habitat preservation, or any other thing other than streets. And then there were a number of reservations by the developer in 1908 to run all the utilities and so forth. So there's really no question that the intent when this right-of-way was first dedicated to the city was that it be used, and the sole purpose of it was for streets. I believe it was Councilor Bonington that asked, was there any compensation that would be due if the city vacated the right-of-way? The answer is no. And the reason why the statute's set up that way is because the city obtained this right-of-way for free. It was dedicated to the city in 1908, and the way the statute works is when the city vacates it, it goes back to the abutting landowners. The reason why it does that is right-of-way is not fee title. Fee title that the city holds is like any other deed, like I presume the land underneath this city hall. And what your deed will say is the city owns in fee title this property and it can do whatever it wants with it for any reason that the council deems. Right-of-way is different. Right-of-way is an easement. It is an easement to the public that the folks that developed the Willamette and Tualatin tracts in 1908 gifted to the city in return for recordation of the plat. And so like any other easement, if I give you an easement and you decide you're never going to use it, you don't pay for it, I've just given it to you. And after 110 or 115 years, you don't use it and you say, all right, I don't need it anymore. That easement would go back to the abutting property owners. And that's actually in Oregon state law, in the statute. So that's really how this is intended to work. I want to clarify at the outset, following that thread, is that this is not a park or any other habitat area that the city owns that it would be obligated to protect. And what's interesting is that the city charter actually has in it very strict protections for its own parks and open spaces. In fact, my understanding is that the city cannot sell or grant an easement on or dispose of its own parks and open spaces and habitat areas in any way without a citywide vote. But that's not what this is. Those types of open spaces and parks are defined in section 1.100 as streets, highways, avenues, lanes, it's a city-owned real estate identified in documents adopted or accepted by the city as open space, green space, wetland, drainage way, wildlife habitat, and stream corridors. This is not that. This is a street. It was given to the city in 1908. The city hasn't used it. So I just am encouraging the council to keep that in mind as it listens to the testimony that I think you're going to hear, assuming that it's consistent with what I've seen in writing. I understand that there's a lot of concern by the neighbors about future development of this parcel. But again, the proper venue for that fight is as part of a development application. That's not, again, why we're here tonight. The final thing I want to say before I sit down is that to the extent that this council is going to be encouraged to use the vacation process as a growth control, I would caution against that. The council has at its fingertips a voluminous land development code that has very, very strict growth controls for the city. That is what it's intended to be used to decide whether and how land is developed. But the vacation question primarily is whether or not the city still needs this particular roadway for transportation. We've shown that it does not, so we've met our burden of proof. Your city staff agrees that it will not be used for transportation. And for those reasons, we would encourage you to grant the petition for vacation tonight. So if you have any questions, I'm happy to answer them.
Thank you for the presentation. Councilor Groner has his hand up.
Yes, thank you very much for the presentation. I'm wondering if it's out of order for me to ask what's the motivation for this process?
Entitled to ask whatever questions you want. So go ahead.
We do have a plan for development of the site. It wouldn't include the areas included as right-of-way as developed. There is, like I said, a portion of the very northern part of 5th Street that is potentially development appropriate. And it's our burden to show that, and we will obviously submit that under a different application. So part of that is just cleaning up the plat, providing one lot under ownership. There are some benefits to not having public right-of-way on the site. In your development code, that is not going to be developed. It could be maintained. The habitat on site can be used to do restoration as identified in the code as well, under that right-of-way area.
Thank you very much. That clarifies things for me.
I asked the same question actually before the hearing, because I've only been recently brought into this. And my question was, are any of these rights of way themselves proposed to be developed? And my understanding is that, or I believe at least 90% of the area, the answer is no.
Council President Baumgartner, go ahead.
Thank you, Mayor, and thank you for the presentation. I had the same question. I wrote, if not using vacated areas, why is the vacation necessary?
As I'm
Yeah, I think that's the question that Mercedes was trying to answer. Did you have a different angle on that question?
I didn't hear an answer yet.
So the area, there is a portion of the area that is developable, which will be our burden to prove in another application. We're not proposing any development on it currently. The city has no plans, as identified in our pre-application, to ever develop these roads with utilities or roads. So this would bring this all under one ownership that allows us to provide restoration of the habitat in accordance with your code, which is required as part of development application. It allows us to provide density on the site that's appropriate. It allows us to use some of the PUD criteria in the future as one lot rather than a bifurcated lot. And it allows these areas to be protected and maintained potentially in a future tract, all one tract, rather than in city ownership that is not maintained.
Okay. Do you have a tax lot map that shows the cleaned up tax lots and how the tax lots, you said all these right-of-ways are on one tax lot?
I don't have that was submitted to the city and has been approved. There is a preliminary plat approval.
So in that applied for plats, are these right-of-ways all on one then?
It cannot be approved until we have the right-of-way that bifurcates the two parcels.
Okay, I understand.
Vacated. But we do have one that shows one tax lot. It's north of the pond, and everything north of the pond is one tax lot instead of multiple tax lots.
Got it. And are these right-of-ways in one tax lot or more than one tax lot?
They would be primarily, or I believe all in that singular tax lot. They are kind of on the edge, so I would have to look perfectly at a map and see how they've realigned, but.
Okay, thank you. So back to my question about signatures. So I think I heard that some people did sign.
So we had our property owner sign that met the burden required by law to provide 2/3 of the affected property owners. We included the other property owners that are affected as well. However, we are not required to seek or provide their signatures if we meet the 2/3 requirement.
So Mr. Bob Schultz is the only person who signed.
Yes.
So there are no signatures from other property owners?
No.
Okay. It seemed it was a little bit unclear, but thank you for clearing that up. I appreciate that.
Councilor Bright.
So my question is, if you want to come in and develop to this extent, wouldn't it have been a nice gesture to actually reach out to those affected homeowners instead of just saying, we've got the percentages, we don't have to do it? I know it's not a requirement, but wouldn't that have been a nice gesture?
Yes, I understand what you're asking. And yes, it could have been a nice gesture. Again, in this development, we were working with the affected area and the requirements, and we sought to meet the requirements and submit to the city.
I want to follow up on those two questions because I think that what those questions imply is that people are concerned about development of this area. I don't think that there's a whole lot of folks that are concerned about their inability to improve these rights of ways and use them to access their property. So along those lines, my understanding is that there has been a neighborhood about a future development, and that process has a lot of procedural safeguards to it that the applicant is undertaking in order to file an application for development. None of those things are required either in the city code or in the statute for the simple vacation of unused right-of-way.
I'm going to go to Councilor Bonington and then we'll continue the questions.
So thank you for addressing that difference between fee simple and right-of-way. Some of my questions are sometimes Socratic, but yeah, this seems a little quiet today. Is it? No. So back in the 70s, before this had the same sort of features to it, it was not necessarily a wetland, it was more of what seems to be a farm. It seemed like it may be a viable thing to put a road through here or utilities for whatever reason in the future. But at some point when that changed, now that doesn't make any sense to us. Is there any reasonable expectation whatsoever that that might change back in the future?
So my understanding of the property and the site is that over time, that area has become the wetland has become enlarged by the large beaver population and the culvert in the road on 4th Avenue. And so that area now is a protected area, whereas before it was not a protected area when these rights of way were established. So no, I would say there is not any expectation that roads would go through in these areas or utilities at this time, is my understanding.
And from a legal and land use planning standpoint, I will be far underground by the time I can see any possibility of the state of Oregon or this local jurisdiction dismissing altogether its wetland protections and seeking to drain existing wetlands. So the fact of the matter is, I don't see any possibility that these roads will ever be used for public access, at least not public access of the type that you could easily walk on or drive a vehicle on.
Thank you.
Yes, I'll jump in with one question. I'm struggling with the issue of the definition of whether the public interest will be prejudiced by the vacation. It just seems so broad. And Mr. Stevenson, you in your opinion, it would seem that it's kind of like, is it used for a utility or a road? That kind of is the public interest question in your mind. Have you ever seen it? Is it ever broader than that? Like,
well, ultimately, the city can make a lot of different calls on what's the public interest. Where I see the difference, and over the years, I've struggled with this and this is, I apologize for those counselors that find this stuff really, really boring, but sometimes you'll see rules written that says shall conform to X. And then other times you'll see a very similar rule that says shall not be inconsistent with X. Now, in the legal world, those have two different meanings. And so if I saw a standard here that said, if let's say the criteria was written, if it's in the public interest. Well, I don't know what the public interest is. That's for you guys to determine. But when it says something like will not prejudice the public interest, and then I read the rest of the statute, because I, like everybody else, want to know what that means. And unfortunately, the statute doesn't really tell you what it means, except that you can kind of figure it out from the context of the rest of the rules surrounding vacations. And so I look at what are the other criteria? Well, you have to have the consent of all of the abutting landowners. That's criteria number one. Second criteria is you have to have the consent of 2/3 of the affected area. So what does the legislature want us to try to get at there? What I look and see is that they want to figure out whether folks who might need to use that right of way will not be able to use it, and that will be a problem for them. And when I look at that third standard in that row, I say, well, okay, when you look at this isolated, it's very, very difficult to understand what they're talking about. But when you look at it in the context of the rest of those criteria, the way I interpret it is the question for a local government is whether or not, at the end of the day, it has an interest in maintaining this right of way for the purpose for which it was originally dedicated, which is as a road. If it could be anything under the sun, I think that the statute would have said that it has to be in the public interest, however the city may determine that. But it doesn't. It just says the public interest shall not be prejudiced. So that's my view of the statute. Reasonable minds can differ, and free legal advice is worth what you pay for it, Mayor. But that's how I read it, because of the way that those first two criteria are really trying to seek the impact on the abutting property owners. The other thing I would say is that when you look at who has standing to appeal a vacation decision, it's those affected property owners. It's not anybody in the city. It's not, and I just want to correct the record, we don't go to LUBA on this, we go to circuit court if it's appealed. So it is not like a land use proceeding where anybody who testifies in writing either or orally has standing to go to LUBA. The statute's very specific that those affected property owners, and I read that as within the affected area, have the ability to go to circuit court and contest the vacation.
Thank you for the answer. You know, I'm just, it seems like it's the crux of this hearing is on that particular
Absolutely
public interest, and I'm trying to find a case interpreting what that means. I couldn't find one. I haven't seen a legislative history on it. It's a weird situation where city council is asked to interpret a state law. So we're kind of acting like a court in that way. So
you absolutely are. And I was telling Mercedes earlier that I've done dozens of these over the years. I've never once had one be contested, simply because typically it's really clear. Do you still need the right of way? Does the city have any interest in maintaining it for transportation purposes? And do you have the requisite of consents? So yes, I think we're all somewhat new at this.
thanks. Any other questions? Sorry to take up time there. I just wanted to ask that one.
No.
If I can just add a few points.
City Attorney Dougal, is that how you say the last name?
That's correct, yeah.
Okay.
So
Go
if I
ahead.
could just add a few extra points there. First, there is, there's a little bit of flexibility in whether this is a land use decision or not. I think it depends on the city's common treatment of the vacation. Any written ordinances or regulations that you have regarding the vacation, which in this case you don't, but as I understand it, you do have a common practice of treating these vacations as land use regulations and holding quasi-judicial hearings when you decide these vacations. And so we are proceeding with the more stringent requirements of a quasi-judicial land use proceeding to fulfill that requirement. And in that context, it could arguably be appealed to LUBA. So I just wanted to add that. Second, I think, there is reasonable minds can differ on the interpretation of the statute. There is a lot of discretion in how you as a local entity decide to interpret it. And you can exercise that discretion in your development code or in your municipal code if you desire. Other entities have done so, but you have chosen not to further interpret it at a local level at this time. So you do, unfortunately, only have the statutory language to go off of. But in that context, you do have a lot of discretion. That language is pretty broad. And so interpreting that, you can take the narrow statutory interpretation that Mr. Stevenson was just describing, essentially saying, does this piece of land, this right-of-way, does it or can it serve the intended purpose of right-of-way usage, road usage, utility usage, et cetera? Or just generally when you consider public interest, which, as Mr. Stevenson pointed out, can be a discretionary definition, right, of what that actually means. Is that prejudiced in any manner through this vacation process?
Thank you. Good points. We'll move on pretty soon to the public comment phase, but I'll have open for any other final questions for the applicant. I know they'll be up again for a potential rebuttal. Council President had a.
Thank you. Yes, thank you. In fact, this might be a question for Attorney Dougal. So who will have standing to appeal?
Yeah, so at minimum, the neighbors, right, exactly as Mr. Stevenson described, but also to any interested parties. So any individuals who have spoken up at this hearing, have testified, and essentially have a stake in the decision-making process.
Thank you. So just to be clear for my own understanding and those present, the standing to appeal goes beyond those who were consulted and whose signatures were not required because they were not necessary. So the standing to appeal extends beyond
So,
just the property owner himself.
assuming that this is still applicant's time, I want to weigh in on that. I want to agree with Ms. Dougal in that it is ambiguous in the statute who has standing to appeal. If you're appealing, the only thing in the statute in Chapter 271 in this area says any property owner affected by the order of vacation or the order awarding damages or benefits in such vacation proceedings may appeal to the circuit court of the county where the city is situated in the manner provided by the city charter. So the way I read that, and I'm not foreclosing the possibility that somebody could appeal this to LUBA. Should they do so, because the local government has no separate criteria concerning vacations, I would probably file a motion to dismiss. I think that if somebody wants to appeal, they got to go to circuit court, is my guess. But I don't have a definitive answer to you or for you. I do think that the intent here, because it's not living in the city's land use statutes, which are governed by ORS 197, 197A, and 227, that we're probably not in LUBA land. But certainly if somebody wants to appeal, we'll probably figure that out.
And I would just add, I would agree with that. I mean, it's unfortunately not clear because, like I said, it's not in your development code, but it's also not in your municipal code. So there's not a clear answer for you. An individual, an affected property owner or an affected party who shows up to this hearing and presents testimony or files written testimony could attempt to file at LUBA, and then they could also proceed under 271-130 if desired in circuit court.
Thank
or
you.
attempt to.
And the reason why I mentioned that, it wasn't to talk about how we actually deal with appeals, but was to look at the context of the statute to figure out who it's trying to protect and why. And that was part of my answer to the mayor's question.
Thank you.
I'd like to, at this point, if without any objection, move to the public comment phase. I know we've got a lot of folks who've been waiting. So we will move to that and go back. If you wish to testify during the hearing, you must complete a sign-in form, which is on the table over by our security officer, and submit it to staff. And when you're called, state your name and city residence for the record. You'll have up to 5 minutes to speak. Is it 5 minutes or 3 minutes under the rules? This says script says 5 minutes.
I
5
trust the
minutes?
script.
Okay, 5 minutes.
Thank you, Mayor and councilors.
Yeah, and then any written material or other evidence you submitted has been distributed to members of the council, so it's placed in the record. And I just want to say I've appreciated how everybody has been so far in the hearing from the standpoint of being keeping your cool. And I'd just like for this part, please no applause or reactions to comments. I know there's a lot of feelings about this particular property and the area. So just trying to keep it professional. I've really appreciated how everybody's done so far tonight, and I expect that from everybody going forward, including applicants. So with that, we'll call up the first speaker, and I know we've got several tonight.
Kathy Halicki.
Hi, Kathy, welcome. Just state your name and city residence and take it away.
Kathy Halicki, President of the Willamette Neighborhood Association, and I'm speaking on behalf of the Willamette Neighborhood Association Board. Dear City Council and Mayor, the Willamette Neighborhood Association Board would like to request a delay and/or continuance on the decision of this item until staff can meet with the WNA members and educate us. This again shows a lack of communication and transparency. Actions speak louder than words. According to the documentation, staff has had 4 months to reach out to the WNA to come and explain or educate us on what the benefits and drawbacks of a street vacation are. This was not done. Most of us are not engineers nor land use experts. Our members like to be informed as to what is going on in their neighborhood and why. Looking at the application before you, like you mentioned, Councilor Baumgartner, Council President, none of the surrounding property owners, besides the LLC, signed the sheet. Were they even informed? Were they educated on the ramifications, both good and bad? That was not included. This was not included in the applicant's meeting at the WNA meeting. None of this was discussed. WNA is having a meeting on Wednesday at 7 o'clock at the Adult Community Center. This is on the agenda. We would love it if staff could come and educate us on this topic. We will then present you with our recommendations, pro or con. And just for your information, at the WNA meeting that the lawyer discussed, the applicant gave us absolutely no information. The answer to all the questions were, we don't know at this time. So, and when asked, are you coming back when you do have some answers? The answer was no. So he could not tell us the number of lots, the number of residences, how much they were going to be, the size, or the size of the lots. So for this reason, the WNA board is requesting a delay and/or continuance, perhaps to your next business meeting, so we can give you our feedback after we are educated. Do you have any questions?
No, I will just note that a continuance has been requested, and I remember from the script that that is something we'll have to discuss. I don't know if we discuss that now or later on.
We can discuss it now if you prefer. It just should be before the end of the public hearing.
Okay, but we can discuss that now, I suppose. So unless there's any follow-up from Ms. Halicki, we'll just transition to the city attorney.
Thank
to
you
discuss
for your
the-
comments.
Yeah, thank you. So there's been a request for a continuance, and it's the first evidentiary hearing, so.
Correct. So you have two options. You can either grant the request by continuing the public hearing, or you can leave the record open for additional written evidence, arguments, and testimony. So what I heard from the comments just now was that she would like more time to potentially present additional evidence or testimony, review the existing evidence. So you can choose to leave the record open for an additional period of time if desired to accomplish that.
Okay. Should we decide that at the end? We'll continue. Okay, let's continue on with the public testimony, please. Thank you. We'll address that after the public testimony.
Michael Taylor.
Welcome back. State your name and city residence and go ahead.
Yeah, Michael Taylor. A little bit about my background. I have no financial interest in this project. 40 years ago, I was on the Lake Oswego Planning Commission and City Council. And we did, at that time, Cruise Way, both the office buildings and 1,200 homes, plus a bunch of other things. What you're looking at tonight is strictly a vacation of a street. There's a sludge pond in this 35 acre that this gentleman controls. To get rid of that sludge pond, you've got to do an iterative serial process. This happens to be number one in the process. He can't go fixing other things down the road until he gets this step done first. So just as a matter of continuance is sort of, there's going to be plenty of other times that my friends in the Willamette Neighborhood Association can come in and talk about different developments. The wetlands aren't being affected by this. There's no homes being approved. All you're looking at is a street vacation. And so I'd like you to sort of keep that aspect in mind, and knowing that between PGE and their 105 acres and this parcel of 35 acres, you've got 2 sludge ponds and an area that people like to walk. Okay, something's got to give in that area, and it's up to you to watch this process as it evolves. Today, I don't see a continuance. I didn't go to the meeting that Kathy referenced, but she told me that 3 of the members were so rude to the developer that they were kicked out. And when you ask this developer, how many of these, how many of those, he doesn't know until he gets approval. So again, it's an iterative process. We're here to approve the aspect of a street vacation. Thank you.
Thank you for your comments.
Eric Griswold.
Hi there, welcome. Just state your name and city residence for the record. You have up to 5 minutes.
My name's Eric Griswold. I live on Johnson Road, Stafford Hamlet. And it sure seems to me that this is linked to development. But that's not what I'm here to talk about. Can you see this okay?
Yes.
Not too much glare. Okay. Native American elder Chief Joe Copper Jack has authored a way for indigenous people, government, and business to come together to negotiate land use. In these meetings, a seat is reserved for no voice, which represents our planet, forests, rivers, and other than human beings who share the earth. Inspired by the example set by Chief Copper Jack, this photo compilation represents no voice and is a reminder to always consider the needs of our planet and all living beings. I also have turned in a letter of support for the protection of the Willamette wetlands, which has been signed by about 40 members of the Unitarian Universalist congregation at Willamette Falls. Now, you can't develop in that area without seriously impacting the wildlife. The wildlife will be impacted. Just 3 weeks ago, I don't know if you can see this very clearly. I'm sorry, it's not a clear photo. I'll explain it in a minute. Second one. I was driving down Willamette Falls Drive right above the wetlands area, and there was a hawk in the road, a dead hawk, right in the middle of the lane. So I pulled over and picked it up and took it off the road, took some photos, and I went over to the Westland Police Department and reported it, and he reported it to the state police, who then came and picked up the bird. But I've seen an awful lot of road accidents that involve animals over the last few years, a lot of them. And I've seen beavers and other birds and you name it, every kind of wildlife we have along the river here has been hit either on Johnson Road or on Willamette Falls Drive. And if you increase the housing down there, you're also going to increase the number of drivers, and you're going to see more incidents like this. It is going to seriously impact the wildlife. Thank you for taking my comments.
Thank you.
Terrence Shoemaker.
Welcome. State your name and city residence. You have up to 5 minutes.
Terrence Shoemaker, West Lynn. As a member of the Friends of Willamette Wetlands, I ask you to vote no on vacation ordinance 1757. As we all know, a yes vote is the first mistaken step on the road to approving a project that will damage a valuable wetland. The city should retain the right-of-way and work to regain control of this property in order to incorporate it into the waterfront plan as expressed by a majority of respondents to the Waterfront Vision Plan survey. The Highway 43 Vision Plan and the Waterfront Master Plan provide the means for thoughtful, planned residential and commercial development. But the Schultz proposed development is the worst possible plan in the worst possible location, sitting on a steep slope above and encroaching into our wetlands and floodplain. To approve a development in this location defies the spirit and intentions of city codes. There is a spirit and intention in the codes, and there are loophole-ridden obfuscations buried in the codes that allow developers to circumvent the spirit of the codes. For example, Chapter 32.090-C-2 states, for every 1 square foot of planned development area that is disturbed, on-site mitigation shall require 1/2 a square foot of water resource area vegetation to be created, enhanced, or restored. Now, what this means is that with a planned development, there will be a net loss of water resource area. Additionally, Chapter 32.070 and 32.080 provide convenient workarounds for developers to once again circumvent the intention and the spirit of city codes. The proposed Schultz development, which we know is coming, would fail to meet any of the requirements specified in Chapter 32.080, Section B. Additionally, the proposed Schultz development completely violates the provisions of Chapter 24.100, Section B. I urge the council to read this carefully. A planned unit development on Fifth Avenue runs totally against the spirit and intention of the CDCs, especially Chapter 32. If you are hoping to move forward with thoughtful, well-planned improvements along Highway 43 and in the waterfront project area, it would be criminal to begin those projects by granting the right-of-way vacations for the wetlands property because you know what is coming. Even though the Waterfront Vision Plan survey questions were severely flawed, the Pond District survey results still showed the greatest number of responses favored wetland trails with viewing platforms in the visitor and nature center. Schultz's planned development also violates the goals set forth in the Sustainable Westland Strategic Plan. This document provides the best framework and vision for the city to use as a guide for responsible governance. To ignore the goals listed in this document is to abdicate your responsibility as public servants. We need to preserve the last wetlands in the city and prevent an invasive development that will ruin a community, further damage and degrade the wetlands, negate safe routes to school, create extremely unsafe walking routes in a community of narrow streets and no sidewalks, disturb and congest the neighborhood for months or years with construction vehicles, and create a highly untenable situation for emergency vehicles in the event of fire. Our petition of the wetlands, the Friends of Willamette Wetlands, has gathered almost 3,000 signatures of citizens opposed to the proposed development and in favor of protecting and rehabilitating the wetlands. We will oppose this project because it's coming for as long as it takes. And we hope that Mr. Schultz and his current or future investors will hear us loud and clear. We are in this for the long haul. We have discovered documents and studies related to the lack of structural integrity of the settlement pond and its potential for leaking toxic waste into the wetlands. Once these are made public, we feel all citizens in this community will voice their opposition loud and clear. Please vote no on Vacation Ordinance 1757.
For your comments.
Nicole Jackson.
Hi there, welcome back. I think so.
Okay,
Just-
can you hear me?
Yep, just state your name
Okay.
and city residence, and you have up to 5 minutes.
Yeah, I thought I had 3, so I'm glad I have a little bit more time not to rush. Good evening, counselors. My name is Nicole Jackson, and I'm a resident of West Lynn. I appreciate the opportunity to speak to you all tonight to present evidence and share my concerns on this right-of-way vacation hearing. I provided written testimony earlier with additional details. Tonight, I will be highlighting key issues. Apologies if my written testimony earlier was a bit lengthy. I just wanted to include as many facts as possible. So we all know that the impetus for this right-of-way vacation hearing is for development on the property that encroaches on the wetland. There's no need to make this vacation otherwise. However, public interest, as has already been stated, plays an important role in the approval criteria for this particular hearing. Oregon Statute 271.120 has a governing body to determine whether public interest will be prejudiced. My interpretation of prejudice in this context is that it will cause harm to. By approving the vacation of this right-of-way, you will be causing harm to the public interest. We have, as Terrence stated, a Friends of Willamette Wetlands petition with over 2,976 signatures and comments, which were attached in my testimony earlier, highlighting the interest to stop the development and protect Westland's largest wetland, which the developer currently owns about 10 acres of, 9 to 10 acres. There's also the community engagement summary comments for the waterfront vision plan that highlights the community interest in preserving this area with limited development, perhaps maybe viewing platforms or walking trails. And maybe that would be a great use of a right-of-way along Fifth Avenue. There's also, I wanted to note, I apologize if I didn't provide the page number in my written testimony, but in the 2019 Parks and Rec Master Plan, page 61 out of, I believe, 111, the area is outlined as a planned riverfront park as a tri-city sewer water district, I believe. The city was working to make this area a park before it was sold without the city council's knowledge. There is only documentation that I can find of it being briefly mentioned in a city manager memo from a former city manager that this property was up for sale, but it was never brought forth to council to decide if they wanted to purchase this property for themselves from the previous owner, Clackamas Water Environment Services. This shows that the city recognized this area as a place for public benefit. I also encourage you to think bigger than just streets and utilities for right-of-ways. For example, the city of Portland, when considering the prejudice of public interest in vacations, takes into account view corridors, viewpoints, stormwater functions, tree retention, and more. Again, it could be a viewing platform. This area is in the floodplain, and so there's natural stormwater functions that act as a wetland in the floodplain. I also want to highlight some concerns regarding the integrity of the settling pond that were not mentioned in the contaminated media management plan that was provided by the property owner. In the 2014 DEQ documents, there is no liner of the settling pond in any of the testing that was conducted by DEQ and the consultants. There's also a large presence of nutria in the area. I personally have seen about 5 juvenile nutria in the last couple weeks. And this creates a potential pathway of exposure and leaks given the nature of the burrowing and the lack of the liner and the potential for hydraulic communication with the groundwater. This should alarm City Council enough not to vacate until further testing is done with the DEQ, given the developer has already received approval to build along the hillside before remediating that sludge pond. In sum, this right-of-way vacation without any other conservation easements or similar in place gets the developer one step closer to their planned development, which as written currently in the pre-application has significant violations of the city code, including the 100-foot wetland buffer, putting Westland's largest wetland at risk. Does the council want this development to be part of their legacy? At the very least, I ask that the City Council pauses or postpones any decision on this hearing until further evidence can be presented to ensure the safety of the public and the wildlife in the wetland. And as one final note, I also watched the land use training that I believe you attended. And the city has a constitutional right as a taking, which can either be taking of property with just compensation or imposing a limiting sort of easement. So something for you to consider. Thank you.
Thank you for your comments.
Bruce Jackson.
Hi there, welcome.
So first of all, I'm going to apologize because I raised my hand about a point of order.
It's fine. Don't worry
It's just
about it.
I'm an old guy and I was afraid I would forget about this typo. So when you posted the sign, you said that you posted it on 6/23/23. I think you meant 24.
I noticed the erroneous date in the presentation too. It might have just been left over from a past presentation. It's on with the slide with the
It wasn't a
dates.
big deal, but
No.
you know.
Could you state your name and?
Yes,
city
my name
residence
is
for the record?
Bruce Jackson and I am a resident of West Lynn, have been for 31 years plus. And I'm going to declare my background, which is 36 years in construction chemical technical sales. So I'm going to represent myself at least as a specialist. Some people would say I'm an expert on coatings and liners for structures. And I also do a lot of concrete restoration work with pulp and paper. So I've been in every pulp and paper plant up and down Oregon, not so much, in Washington, but I can list them off, but I don't want to bore you. But certainly I've been in them to do chemical restoration and protection so that the buildings don't fall apart, okay? So I'm going to, I have a 2-minute here, and I'm just going to read it to you. I got to take my glasses off because again, I'm an old guy with cataract surgery. So I got the cheap version, which was fixed. So the elephant in the room is the settling pond on this property. It is understood that there would be remediation to this property going back a decade or more. To date, it is not known that any, and especially any proper remediation has taken place. Further, there are no known current reports, current is the emphasis, regarding the structural status of this pond. It is understood that the pond is constructed as a continuous earthen berm, which according to the DEQ, final assessment report from 2014, so that's coming on 15 years ago, indicates that dioxins, furans, and heavy metals were found in this structure. These are chemicals that would be typical of a pulp and paper plant. It is well known that these types of chemicals are used in pulp and paper processing. Fortunately, rules have changed over time due to the understanding of environmental and human health safety issues, and as such, a pond of this type could not even be built now, especially being an earthen bermed, earthen-based settling pond with chemicals in it. If the pond is leaking due to the absence of a properly designed structure and or due to the absence of a commensurate liner, then remediation would be required. The lowest estimate from Clackamas Water and Environment Services, who my daughter, who just spoke, referenced as the previous owner, it was deemed back in 2015 to be in the range of, sorry, I'm dry mouth, of $5 to $10 million. Now, 10 years later, that estimate would be substantially higher. I don't know what it is, okay? Even though the DEQ determined that there was no liner present in this pond for the purpose of chemical containment, they nonetheless relied upon a report that is now roughly 10 years old in order to give approval to the developer, to build on a portion of this property before any remediation had occurred. Final comment. Therefore, in the absence of any remediation, denying this right-of-way vacation prevents, this project from continuing until further testing, is conducted in the benefit of public interest. And that's my comments.
Thank you for your comments.
Connie Johnson.
Welcome. Just state your name and city residence, and you have 5 minutes.
I'm Connie Johnson. I live here in Westland, and I'm a neighbor. I live near where these vacations would take place, and I just want to go on record saying you can't hear me. I just want to go on record as saying I oppose the vacations. I think keeping these hands in public property leaves the options open more for this to be used as something more in keeping with the waterfront vision plan, maybe trails, access to the wetlands without disturbing the wetlands or viewing. And I just ask the council if you can keep this property in public hands and preserve it for the public use as a green space, trails, walkways, viewing platforms. I would appreciate it. Thank you.
Thank you for your comments.
Larry Reed.
Welcome. Just state your name and city residence. You have up to
Excuse me, Larry
5
Reed, in the Westland area. Thank you, Mayor and council members, for taking my testimony. I've lived here in this area for, over 30 years, and I love Westland. I love the diversity of all the parks it has, Camisea, the rocks and the flowers and the Mary Young. And so this would be a great area for more diversity of parks and, like other testimony, for hiking trails and just viewing next to the country's second largest waterfall. It's just a great area, and more time needs to be taken for comprehensive planning. A no vote for vacating the right-of-way is not, as the applicant said, for growth control. It's for the interest of the public, for taking the time to see what really needs to be done with this area. It's just too valuable to just end it. There's too much development that can affect the area in the future, and the applicant hasn't stated the full intent of what he plans to do. Toxic ponds are another problem that should be cleaned up as part of the comprehensive plan and coincided with any kind of development in the area to restore the wetlands. And I think that's all I have to say, just the main points.
Thank you for your comments.
Okay, thanks.
Points noted.
Russ Axelrod.
Mr. Mayor, welcome back. I think you know the drill. It's name and city residence. You have up to 5 minutes.
I do. Thank you very much, Council. Mayor, good to see you. In listening to this tonight, I kind of have to go kind of on and off script, I think, and just talk about a few things. You know, I first got involved, as you know, in really the city, early about 15 years ago as a technical expert serving on our Water Resource Committee. We rewrote Chapter 32 to address really all the complications and problems that we've seen in trying to develop in West Lynn and preserve our remaining water resources that we have. And then in my first year as mayor, realizing that we really needed to master plan the entire waterfront area. We started that in 2016. And I'm really pleased to see it moving on. And recently I commented to you about, offered you comments on what I saw in there. And I was shocked when I saw this area colored as this dense urban development in our wetlands there and in the floodplain. And for all the reasons I outlined in my other comments, problems with that and how this really violated and was in conflict with really the district planning framework that's been developed for this region, which is to demonstrate environmental stewardship and protect and restore the city's water resources. You can't really decouple this decision tonight really from the bigger picture of West Lynn and our planning framework. I appreciate the comments about the sort of myopic viewpoint, but when we've gotten into trouble, and the reason we master plan is because we've had so many complications like this in the past. They start incrementally, slow down the road, and eventually you find yourself in a place you don't want to be, and you have a community disrupted. And I don't want to see that happen here again. Our community wants to work productively with our city planning and avoid or minimize conflicts. Our community is not interested in creating hardships and disruption to our staff or creating unnecessary additional cost or expense for our city or for developers for that matter. But it should be very clear, the only reason for this right-of-way is to support this dense housing urban development in the wetland. And I don't think you can decouple that. And the power and the authority of the council, I think, is to recognize the opportunity where you can to sort of keep the city on track with where we should go. And this is one of those decision points, I think, for council. I've heard discussion about, I really did appreciate City Attorney Dugan's comments about the framework of these right-of-ways. They are much more than just roadways as they've been constructed. If you look anywhere in historical documentation, roadways is a common term used in all the plating, and it has abundant uses. And there's many other uses that serve the public that I think need to be recognized. And several, I think, have eloquently spoken to that tonight. But this development project is not in the public's interest. And you should deny this right-of-way vacancy to protect our city's future options for future management in the area. In this regard, your approval of VAC-24-01 vacations, I believe too, would prejudice the public interest in violation of ORS 271.120. We don't precisely know what the infrastructure needs are going to be in the future. There's a lot of issues around. I've been, after I submitted my comments, I learned about this plan, and I've been sort of digging into the status of the pond, the contamination. As you know, I'm an expert. I've worked for 30, 40 years in cleaning up sites and restoring wetland and habitat areas. And there's still a lot of uncertain issues around this and where we want to go. But the city has outlined in its parks plan and clearly in the framework that's being put together for the waterfront area, a clear vision for this area to preserve the water resources. The water park idea of recouping part of the landscape of the ponds is in there and has been on the docket. So again, I'd ask you to deny VAC 2401, help our planning and development of this district get back on track to where it needs to go. And finally, I'm asking that City Council direct our city manager to have our planning department and the Planning Commission immediately address the loophole problems associated with Chapter 32.080 alternative review process that has been sitting idle on the PC docket to address I think for at least 2 years now. Staff has relied on using this section of chapter 28 or 32, excuse me, to circumvent certain aspects of our code in order to get some projects and actions approved that otherwise would fail.
Could you just wrap up the next few sentences? Thank you.
And no surprise, this is the very section they're relying on for this moving forward. So I would urge you to deny it. And I appreciate your service and watching out for our community. And I want to thank everyone in the community who's commented tonight. It's been great comments. And thank you for staff for hosting. Thank you.
Thank you for your comments tonight, sir.
That is all.
Okay. Well, I want to thank everybody from the community who came out to comment on the proposal. We appreciate hearing from you. And we will proceed now to rebuttal by the applicant according to the process here, and then we will move to the addressing the request for continuance.
Just very briefly before the applicant discusses, and I'm sure that they'll mention this as well, but I would just like to remind council that the decision that you're making tonight is regarding the vacation. And I mean, you've heard this already a few times, but any future land use decision-making regarding that piece of land will come before you in a separate application. So
That's good to keep in mind, especially, council, we have to be impartial and we can be challenged on our bias. So as we go into deliberations, eventually we've got to make sure that we are fair in that regard. Good reminder. Thank you, City Attorney. We can move to the rebuttal. Mr. Stevenson, Ms. Sarah, welcome back.
Thank you, mayors and councilor. Before I jump into it, could we figure out what we're going to do with the continuance? Because that will inform how I handle rebuttal tonight, if that's all right. Because if there's going to be a continuance or open record period, I may save most of my rebuttal for a written response.
Okay.
I don't see an issue with that. If you would be okay with calling a brief recess, we can discuss that, Mayor, and then we can come back.
Yes, and let me just, I was looking at the file here, and I wanted to remind everybody in the room of the 120-day clock. So we have a land use law that says you have to process and approve an application within 120 days, or you can be sued, and then they could compel approval. So we have to decide within 120 days. Now, that period ends March 26, 2025, according to the file. So we have some time, which is nice. Sometimes we're under a big crunch and have to decide quickly, but so did you have a further comment?
No, I appreciate that reminder, but I was just going to say that you can request an extension from the applicant as well of that 120-day period, which we can discuss if we want to talk about your options here.
Okay, so I'm open to talking about the continuance. We could take a recess and then we'll discuss that and then convene back to make the decision. We're in recess. Thank you, everybody. About a 5-minute recess. Take a break. Hey, Tony. Ready? Sorry, I love this stuff. I don't know why. Tell me that. Maybe I'll study the end use. So, I'm sure we're talking today. I can come forward. I don't have a program. Which, like,
Back in my hand. Yeah, she was sure, but that's something that's not. Others. Take down all the trees. Urban forestry that I've got. Absolutely. Let's see. Yes.
Okay, are we ready to reconvene? Thank you. We will reconvene the meeting. We've been sorting out the details of the continuance with the city attorney. So would you like to go over kind of the general procedure, or shall I?
Sure, yeah. And I think we should let the applicant know our intent so that they can, because it sounded like they were structuring their response based on the approach that we took potentially. So the city has two options prior to the conclusion of an initial evidentiary hearing. If any participant requests an opportunity to present additional evidence, argument, or testimony regarding the application. And you can either continue the public hearing, or you can leave the record open for additional evidence and testimony for at least 7 days. So from what I understand, you wish to leave the record open for an additional time period for applicants to, or apologies, for interested parties to present additional evidence or testimony, and then to leave the applicant an additional period of time to respond.
That was correct. That was what I discussed with you. Are you comfortable with that?
Um, uh, Ashley, are we talking a 777? Is that the thought here? Okay.
Well, at minimum 7, so I believe that the mayor prefers to leave more than 7 days for the interested parties to provide additional written comments.
Yes, so the neighborhood association requests some time. They have to hold a meeting to consider their comments. They can't do it individually. So the proposal that I came up with was to close the public testimony, leave the record open for the written testimony, including the neighborhood, to submit by March 3rd, and then allow you to submit as the applicant your final written argument and rebuttal by March 10th. And then we would hold the vote on the 17th. Part of the reason for that is because some councilors are absent from the March 3rd meeting and the March 10th meeting. So we want to make sure the full council's here to vote.
And just to clarify and add to that, I think the intent here would be to have the written comments, have an extended period of time for written comments, but not allow oral testimony at that hearing. That subsequent hearing would be for deliberations of the council only.
That was.
I think we would not have an objection to that in principle. The only concern I have is that if a bunch of evidence comes in on March 3rd and our final written argument is due March 10th, I would ask that we would be able to include evidence in our response to anything coming in on March 3rd, because we will not have time to do the normal 777. In other words, if there's new evidence, we would need to have the ability to respond with evidence. And
You're requesting to submit additional evidence
We may
to
need
respond to the
so I'm
additional
fine with-
evidence.
Yeah,
Yeah.
I'm fine with doing final written argument and like the second open record period on March 10th, as long as that week is only for the applicant to respond, assuming that we've got the burden of proof here.
You're talking about the extra period of time, the additional week?
Yeah, so
Correct,
if we're
yeah.
going to leave the written record open to anybody until March 3rd and then close that, the responsive period would be till March 10th. We would ask to be able to file our final written arguments along with any evidence that we would need to offer to respond to anything that came in on the 3rd.
I think that's fair.
But
He's just saying that essentially if there's additional evidence that he needs to present in order to counter something that, let's say, an interested party brings up between now and 3 weeks from now, if he needs to submit his own additional evidence, that he's allowed to during that week period.
Isn't that usually how it goes?
Well, Mayor, typically what you would do is the 777, where you've got 1 week for anybody to make any comment and offer any evidence. And then there's a second open record period for anybody to respond to whatever came in that first open record period. And then there's a third, which is final written argument. Final written argument typically does not allow you to submit evidence as the applicant.
I see.
And so what I'm asking is that since we're basically getting rid of that second open record period, that we be allowed to submit evidence during our final written argument, because that will be our only opportunity to do so.
And I think that's a reasonable request.
Well, how does the council feel? Yes, so the public will be able to provide testimony, and the neighborhood association will be able to provide testimony until March 3rd at 12 p.m. Then the applicant would be able to submit their final written argument with potential evidence, only responding to things brought up by March 10th at 12 p.m. And then we would have the vote and deliberations of the city council on March 17th at 6 p.m. That's the date that the full council is going to be available. So that was important to me to make sure everybody could weigh in.
Yeah, the applicant would support that.
Okay, may I make the motion? Is that okay with everybody? I know I'm the presiding officer, but I have it all written down. So I move to close the public testimony portion of the hearing, leave the record open for written testimony until March 3rd at 12 p.m. Allow the applicant to submit final written argument until March 10th at 12 p.m. and continue the hearing date to March 17th at 6 p.m.
So Mayor, I'd have to object to that because I do want to do a little bit of oral testimony before we conclude tonight, and then the rest of it I'll provide in my final.
Okay, so you'd like to give some comment right now? Is that what you're saying?
Yeah, so,
Oh, we can then, go ahead, give your comment.
yeah, and then we can close the record.
Okay.
Kind of consistent with what the original plan for the hearing was.
That's fine. I didn't know you still wanted to speak,
Yeah.
so go ahead.
You know, and I also want to be able to give the council an opportunity to ask any more questions if they have some for us. In my initial testimony, I raised a concern that I still have that that this process is being used to encumber or prevent development on my client's property. I can understand that the city can have a very broad view about what the public interest is. It's our position that the public interest ought to be informed by what the purpose of these rights of way originally was, which was to provide a transportation facility. One of the comments I heard that was intriguing was, well, could we still use these for public pathways or for hiking trails and so forth? And the problem with going down that line of thinking is that in order to put a pathway or a hiking trail or anything of that nature in there, you're going to have to fill in wetlands. And the city is actually encumbered by the same prohibitions on filling in wetlands that a private developer is. So I don't see a practical reality where the city is going to be able to easily use these as a future transportation facility of any kind. I know that at least portions of these are actually standing water. So I just want to be clear about what we believe the city can and can't do as a practical matter with these wetlands and within the rights of way should they decide to keep these as rights of way. But more broadly, I don't envy your task. This is not a popular project amongst the folks who sit behind me. I can't speak to the rest of the residents of the city, but it is not lost on me that it's hard to sit up there and make choices in favor of a developer when you've got a lot of your constituents saying, we don't like it. Unfortunately, or fortunately, that's exactly what this statute allows you to do. And we think you should do it because we meet the criteria. I did not hear one person state with any convincing evidence or argument that there is a principled reason for the city to keep these rights of way for the purposes of transportation, the purposes that they are originally intended for. I fully understand the opportunity that this gives to the public to voice their concerns about a land use application that is going to be coming before you. But that land use application hasn't even been submitted. I don't believe that the city has some sort of policy or inbuilt priorities that suggest that a land use application, if it meets your city codes, should not be approved on this property, regardless of whether the rights of way are vacated or not. So I guess the way I would conclude is that the city has had 117 years to decide if it wanted to do anything with these streets, and it hasn't done so. These streets are not going to be used by the city for any future transportation purpose unless the city decides it's going to go to DSL and obtain a permit to fill wetlands that they're located in. Again, my client has no plans or proposal to fill those wetlands. But what's clear to me from the record is that the city doesn't have a reason to keep these unless the city wants to use these as a way to encumber or make more difficult development that would otherwise be allowed under the code near the wetlands themselves. When that development application comes before you, you'll be able to determine whether or not it meets the city's adopted policies and rules concerning development near wetlands or in this area of the city. And in that context, it's entirely appropriate to look at things like the comprehensive plan, the land use plans that may apply, as well as how the city needs to apply its wetland conservation codes and wildlife habitat conservation codes. But again, this is not the context where I think it's appropriate to do so. And I also don't think that if that is the reason the city would wish to deny the petition, the city would be doing so based on very little information because you haven't yet seen an application for development here. So again, I understand the pressure that you're under. I understand that you do have discretion here. I would encourage you to consider that these vacations are typically done for a confined purpose. They are not growth controls. They are intended to determine, at least in my view, whether or not the city has an interest in maintaining these rights of way for transportation. We submit that it is not. So I'll do my best to respond to the comments that we've heard tonight in writing, certainly by the deadline of March 10th. But that concludes my presentation, and I'm happy to answer any questions you may have. And Mercedes is here to answer any questions you may have as well.
I'd like to ask one clarifying question, and I apologize for this, but just to clarify your request for the additional evidence or the potential need for additional evidence, are you meaning that during that final 7-day period for rebuttal, you would potentially introduce additional evidence depending on when the arguments come in from interested parties?
So, yeah, so if we're going to have open written testimony until March 3rd, there may be new evidence that comes in that we need to react to. And if the city's position is that we have the burden of proof, if we see evidence that we need to respond to, and we need evidence to respond to that, we will not be able to put that evidence in, obviously, within that first open record period. So we're going to need to do it that following week on March, that ends on March 10th.
Got it. Yeah. So and I apologize for misunderstanding what you were asking originally. We can make that work, but it is not permitted in your final rebuttal period. That's for arguments only, but we can have you file a written request to keep the record open in a limited context for a limited period of time for you to respond in that way.
Well, I think that what we would do, Ashley, is we would just basically leave 2 open record periods where anybody can provide testimony in response to what comes in during the first and the second. We can just provide our final written argument during that same period.
That's great. Just as long as it's not your final period of time for written arguments, right? The final 7 days.
No. What I was suggesting we do is basically we will obligate ourselves to provide our final arguments or whatever during that second open record period.
Perfect. Thank you.
All I need to know is that I can respond to materials submitted prior to, on or before the 3rd with both argument and evidence on March 10th.
Yes.
Okay, great.
We'll figure that out.
A lot of procedure in land use laws, folks. Okay. Well, are we still on track with the timeline proposed earlier?
Yes.
Okay.
Do you all have any questions for?
Any questions or any questions about the timeline? That was, we'll have to let the council weigh in if you have any proposed differences to the timeline. Okay. Mary says, go on. Oh, we'll go on. I move to close the public testimony portion of the hearing. Leave the record open for written testimony until March 3rd at 12 p.m. Allow the applicant to submit final written argument until March 10th at 12 p.m. and continue the hearing to March 17th at 6 p.m.
Second.
Okay, it's been moved and seconded to close the public testimony portion of the hearing. Leave the record open for written testimony until March 3rd at 12 p.m. Allow the applicant to submit final written argument until March 10th at 12 p.m. And continue the hearing to March 17th at 6 p.m. Any discussion? Thank you very much, everybody, and thank you to the city attorney for helping us through that portion. March 17th also is our regular meeting, so I will have this will be the first thing on that agenda that evening. With that, call the roll, please.
Counselor Bragg?
Yes.
Council President Baumgartner?
Yes.
Counselor Groner?
Yes.
Counselor Bonington?
Yes.
Mayor Bielostowski?
Yes. So the motion passes and the hearing is continued along those lines. I want to thank the members of the public, applicant for being here, and for the respectful nature of everybody's discourse tonight. I really appreciated that. So thank you so much. And this is exactly how the process is supposed to work from the standpoint of public input. And just know that your city council is considering everything that you brought before us. So we will continue this on the 17th and have the vote. And at that time, there won't be public testimony taken. We will just be having deliberations. And any other comments you have can be submitted in writing until March 3rd at 12 p.m. So with that, we can move on the agenda, I suppose. But late into the evening tonight. Thank you, Chief Mahuna, for sticking around. We're going to talk about our ordinance related to the feeding of wild animals in West Lynn. This is Agenda Bill 2025-02-10-05, Ordinance 1756, relating to attracting or feeding wild animals and amending West Lynn's municipal code. Folks file out from the public. So, welcome back, City Attorney Klein. Thank you for being here. This is the hearing to discuss the ordinance and potentially vote on it, as this is a business meeting. And City Manager Williams, do you have any introductory comments to this, or should we?
Mayor, you have the experts here. Thank you, Chief, for waiting through that last agenda item. This is an item you have talked about several times, including most recently in a work session, and directed us to bring this back for adoption. City Attorney and the Chief of Police can answer your questions about the impact of this ordinance and the need for it. I think it would be good to have one more time around the block, just a reminder of why this is proposed and what the problem was and what the solution was. A reminder that the ordinance has changed somewhat from original versions in response to questions and concerns and ideas that we heard from the community. So maybe we'll ask, since Chief stayed late, now we'll ask him to do a little intro on why this is needed.
Mayor, Council, Council President, thanks for having me again. As you know, back in September of 2024, we took some public comment, came before Council about a potential problem with feeding of wild animals. It was attracting skunks as an unintended consequence. It was bringing skunks into the deal, into the neighborhood. It was disrupting everyone. We began looking at the problem, looking at the enforcement under the current code, and it was choppy or clunky at best. And so we looked for ways to more adequately address this problem. In digging in, we found out that it was not just one residence that was, or one instance of this happening. We found several more over the last couple of years that we kind of tied to the same problem with our code. So we began looking at trying to amend the code, and we looked at several jurisdictions around us about how to draft it in a way to best address this issue. So like City Manager said, we've now discussed this in front of Council several times. We've made changes along the way, taking community input under consideration, and we believe that this new ordinance will add new sections to the West Lynn Code that allow us to officially address the wild animal feeding situations that have risen to the level of public nuisance. So it's not just a prohibition on feeding animals or birds. It has to rise to the level of creating a nuisance, public nuisance or health standard for the surrounding properties. And so we think this is a great compromise for that. And so we've brought it back to code tonight, Council tonight, I mean.
Thank you, Chief. Do we have any public comments on this? I feel like I think Tony Bracco had signed up for this, if I'm not mistaken. Oh, come on back up and give a comment if you want to on this topic. I thought I saw a form that said this wild animal feeding.
And again, Tony Bracco, West Lynn resident, not speaking as a neighborhood association member, but as a private citizen. I am glad to hear that there have been some amendments to it. However, I did write something that I wanted to read. I think still feels to me in spirit of what I was feeling about this. And First of all, as a person who has a lot of wildlife that does show up on my property unintentionally, sometimes even coming through my cat door at night to help themselves to food in the laundry room, I am against the city creating an ordinance that has been mainly driven by complaints against a single person, although now I hear there have been others. Hopefully I'm not on that list, but could be. This seems so ridiculous to me that they would, that we are doing this, creating a new way for neighbors to complain and turn on each other and rat each other out, pun intended. But I believe we do have ordinances for nuisances of trash creating vermin. I believe that already does exist. So do we really need to create a new ordinance for a small portion? And if someone is feeding their cats outdoors and it attracts other local wildlife that has already adapted to humans and is living hidden amongst us during the day, should this be a crime? And what will punitive fines or punishments really do to solve this perceived problem other than burdening citizens? Are we now going to waste city and police resources by policing and monitoring citizens to keep them from feeding wildlife? Are we going to penalize our citizens based on the say-so of neighbors, or will there be Big Brother monitoring to prove this is occurring? Will neighbors now have to be videotaping other neighbors and then turning them in? Again, this all seems pretty ridiculous to me that we would do this. Thank you very much.
Thank you for your comments. So follow up to that or get into deliberation of the ordinance. I would just add that we learned at the last meeting about our current municipal code nuisance enforcement, and that itself requires hearings before the city council. And so when we're talking about neighbor on neighbor disputes, this is a better way to handle that, I think. And obviously our police department takes a education first approach, and this is really meant to address public health situations where you have, many skunks coming into a neighborhood that are being fed by a person, and other similar situations which we learned about that have happened. So this isn't about a big brother coming in and trying to stop you from feeding your birds, your squirrels, whatever. It's just about those really big nuisance situations that we realized we didn't have code for. So for me, that's where I'm at on it. And I think the current process doesn't work, and it requires city council hearings and very public abatement procedures. So we don't, that's where I'm at. With that, any other comments, or we can move into discussion of the ordinance? We have some motions in front of us.
I move to approve the first reading for ordinance 1756 relating to attracting or feeding wild animals and amending Westland's municipal code and set the matter for second reading.
Second.
It's been moved and second to approve the first reading for ordinance 1756 relating to attracting or feeding wild animals and amending Westland's municipal code and set the matter for second reading. Any discussion? Anybody has any comments?
I will just say thank you, Mayor, that I appreciate this has turned into a rather heated topic in some social media circles, and I just want to assure if people are following this discussion right now, this is exactly as the mayor said, not an opportunity for the city to overmanage or micromanage. It's simply a way for the city to respond responsibly and to support public safety, and in a process that will not, I'm sure, impact or even affect or be made aware of by a majority of the community, just because everybody's going to continue doing mostly what they're doing, which is reasonable. So I'm glad we had this opportunity to assist the community in this way. And I thank the police department for their assistance in this, and our city attorney, Kaylee Klein, also. Thank you.
Councilor Bonington, go ahead.
Just real quickly, I have come to be made aware of 4 of these situations currently going on. I don't know that they've all been reported, but that just strikes me as the best rebuttal to the accusation that we're making a law around one particular instance of something. My understanding is that these happen regularly and it's far from isolated. So I'm glad that we've also added the fact that it needs to be an actual nuisance, but it's not an isolated incident. This isn't a one-time thing.
And I would just add that other cities also have similar codes that our staff drew from in their working up of this ordinance with the community. Councilor Groner, any thoughts? Councilor Bright, we could call the vote, please. Thank you.
Council President Baumgartner?
Yes.
Councilor Groner?
Yes.
Councilor Bonington?
Yes.
Councilor Bright?
Yes.
Mayor Beaslowski?
Yes, thank you. So passes unanimously. So with that, you can move to the second reading ordinance.
Thank you, Mayor. I move to approve second reading for ordinance 1756 relating to attracting or feeding wild animals and amending Westland's municipal code and adopt the ordinance.
Second.
It's been moved and seconded to approve the second reading for ordinance 1756 related to attracting or feeding wild animals and amending Westland's municipal code and adopt the ordinance. More time for discussion. Nobody? Okay. Let's call the roll.
Councilor Bonington?
Yes.
Councilor Bright?
Yes.
Council President Baumgartner?
Yes.
Councilor Groner?
Yes.
Mayor Beaslowski?
Yes. Thank you. So the motion passes unanimously. I thank all the members of the public who weighed in and helped us craft this, and our police department staff for their support, city attorney's office as well. So across the finish line. Thank you. Thanks to members of the public for sticking around for that discussion. So, continuing on, we are now at business item 6C, agenda, which is the proposed 2025 historic inventory of the Robinwood neighborhood. So I'll turn it over to City Manager Williams, and I'm not sure any of the staff coming up.
Thank you, Mayor and Council. I'll keep this brief because there's more information in the packet. I let Darren go home, so you're stuck with me with a middle range of knowledge on this issue. But what I do know is through the years, the City of Westland and all the other certified local governments having to do with historic preservation in Oregon are eligible recipients of a grant to do work about historic preservation in the community. You had a joint meeting with the Historic Review Board in which they presented some thoughts about work program moving forward. One of those items was a inventory of the Robinwood neighborhood, and I think this was came from a couple of different sources. One was the other areas of the city have been studied. Robinwood certainly has older homes and structures that may qualify for historic designation. Another is sort of a matching component to the Vision 43 work being done. So what else can we understand about this corridor? The question on the table is, would you like to support a grant request for a historic inventory of the Robinwood area? That is the Highway 43 corridor north of Mary S. Young Park. All the inventory would do would be providing grant funding with a matching time or resources element from the city to assess. I think the number was somewhere around 560 properties in the Robinwood area to evaluate them for their historic value. The inventory is only that. It provides information. It is information that commercial or residential or public property owners could use to consider doing designations of property. This process wouldn't do those designations in any way, it just provides inventory information. It can also provide information about whether there's enough there to consider a district, historic district. And I have no idea if that would be the case in this area or not. We obviously have one in the Willamette area. Other areas have been studied and not found to be, or not create, districts were not created in those areas. So since the HRB presented this request to you, we scheduled this item with a little more context and a staff recommendation or options to either move ahead with a grant request and do communication in the area following the submittal, or delay the grant request until next year, which we can do, and do a little more outreach and information sharing in the neighborhood before moving forward. The timing of this agenda item is because of the timing of the grant cycle. So we realized that to follow up on the HRB request, we needed to bring you this question right now. And I think from the staff perspective, it would be fine to delay it, but your HRB provided a recommendation, and we wanted to carry that forward to you.
Thank you for doing that. Councilor Groner has a comment, then we'll go to Councilor Bright.
Just a question. Would this actual inventory be done by city employees or by volunteers? Or
Be a hired consultant paid for
Okay.
with the state funds.
Councilor Bright.
Well, I would say ideally, a discussion should have been had with the neighborhood association before this, but I realize the timing, you don't necessarily know when there's going to be grant funding available. Because it doesn't require anybody to do anything, then I think that it would be fine to go ahead and proceed, but then have staff or even, myself talk to the neighborhood association and let them know that that we're putting money in for the grant. What does the vice president of the neighborhood association?
Vice President gives a thumbs up. So that, I guess the question is for, oh, there's a motion here, not even just by consensus. So there's two motions, one for February 2025, one for February 26th. And I think that it seems like everybody's okay with doing it in the 25 this coming year, unless I guess the only question I have is staff capacity to fill out the grant form. Is that, I don't want to overburden anybody.
No, I think it's fine. The two main impacts, I think, are just the processing the grant and the communication that we want to do in the neighborhood. But I heard an offer of council to assist with that, so we would gladly accept that. It shouldn't be too onerous.
What do you imagine the matching cost will be?
It's a one-to-one match, but I believe the one-to-one can include staff and volunteer time.
So you're not too concerned about that?
No.
Okay. Any other questions or comments, or I entertain a motion?
Thank you, Mayor. I move to support a grant request in February 2025 to develop a new historic inventory for the Robinwood neighborhood, with the understanding that the city must provide a 50% matching fund for consulting services.
Second.
It's been moved and seconded to support a grant request in February 2025 to develop a new historic inventory for the Robinwood neighborhood, with the understanding that the city must provide a 50% matching fund for consulting services. Any discussion? Seeing none, go ahead and call the roll.
Counselor Reich?
Yes.
Council President Baumgartner?
Yes.
Counselor Groner?
Yes.
Counselor Bonington?
Yes.
Mayor Bilastowski?
Yes. Motion passes unanimously. When will we have a dissent up here? It's passing unanimously tonight. Well, thank you, everybody. And so the members of the public, have a good night. Staying late with us tonight. Well, we're 8:45 and we're at the Stafford area urban reserves updates. We've got some information from the city manager. And I think help from the city attorney on this. This is just a discussion that I wanted to have with the council, and the staff did as well. And I'm glad we got it on the agenda related to the Stafford urban reserves. There's always stuff that goes on related to Stafford. Like in this legislative session, there's been bills introduced that relate to it. We've got several intergovernmental agreements and things that predate all of our time on council. So I wanted to make sure we were able to get up to speed. And I really recognize it's late. This is always can be a continuing conversation, but I wanted to make sure to have it.
I think we can do this relatively quickly, but we can go deep on this too. I've been working on this, in and around this, for 20 years now, and it never ends. And many people have been in and around it much longer. The Urban Reserves and Rural Reserves program was a program that I actually managed at Metro before I came here to West Lynn. And Stafford was one of the most complicated parts of that right from the start, always was, always will be. Passions run high in the Stafford Basin. It's been sort of the center of a debate about agriculture, forestry, open spaces, urban development for many, many years. People hold very different opinions about that. The one thing that's clear about the Stafford Basin is it's a little bit of a unicorn. It's the only place inside the main freeway ring that is outside the urban growth boundary. And so it has a freeway exit that serves rural land. It's interesting. The three things that we wanted to cover real briefly tonight was the status of that state legislation that you talked about, the status of a legal case that is proceeding through the courts in LCDC, and a study done by Clackamas County. It's not my intention to go into the history of the Urban Reserves Program, although I would surely love to do that. But the main thing you need to know is something that the mayor already said, is that the region and Clackamas County made a decision to designate the Stafford area as what's known as an urban reserve, which means that it's available, first priority for use for urban uses in the future, should the region need additional urban land. That designation, as I mentioned, was complex and controversial. And in order to provide more clarity about how it would work, there were two subsequent intergovernmental agreements created. One with Tualatin, Lake Oswego, and West Lynn, as well as Clackamas County and Metro, that talked about some of the future planning that could happen and how it would happen. And then 2 years later, the three cities, Tualatin, Lake Oswego, and West Lynn, signed a further intergovernmental agreement that created more detail and stricter timelines for future planning work. And the key thing is what I included in here is the agreement that we have with those other two cities, which are the three cities that border the rural area that we're talking about. The two key parts of the agreement is that before any development in Stafford happens, 3 lanes on I-205 are needed. Part of that discussion at the time was you can't have urban development unless you have urban level transportation infrastructure as a baseline. Also, it said that no concept planning for areas north of the Tualatin River can be done before May of 2029. So it was a pretty long timeline. That was a 10-year timeline at the time. And we're more than halfway through that now, so things move quickly. Those agreements and the designation itself were not universally loved. There are some property owners out there that have an interest in development of their property. These are typically more focused around the Wonkers Corner area and the Stafford Road interchange, but not entirely. But that flat area near the freeway entrance has been certainly discussed at a higher level of detail than other places. So things keep bubbling along and bubbling up. And the purpose of this discussion is just to provide an overview of those three things. And we're going to start with in the order of the staff report. So I'll turn it over to Kaylee to talk about this Marks LCDC case.
Hi, good evening, Mayor and councilors. Given the time of the hour, I figured I'd just give a high-level overview of the status, and then if you want to meet with me individually, we can dig in deeper to the particular decisions and the Court of Appeals case. This may be familiar to you or not, but just in terms of a highlight, we're talking about the Marks versus Land Development and Conservation Commission case. This case has been making its way through LCDC and the Oregon court system since 2020. As John mentioned, Mr. Marks is a landowner in the Stafford area, and he's asserting that the 5-party IGA and the 3-party IGA violate Metro's regional framework plan. In other words, essentially saying that these public agencies have unlawfully created contractual barriers to the development and urbanization of the urban reserve known as Stafford. So in September of 2023, The Court of Appeals reversed and remanded LCDC's prior decision that dismissed this complaint on jurisdictional grounds. So the Court of Appeals disagreed and determined it was a land use decision and sent it reversed and remanded back to LCDC. It sat there for quite some time, over a year, and in January, just recently, 2025, LCDC staff recommended that the commission decline to issue an enforcement order against the 5 local government parties, which includes the city of West Lynn. At this meeting, LCDC voted to adopt that staff recommendation and directed their staff to prepare a final order that would be consistent with that motion. We are expecting that final order to come down soon. And when that does, Mr. Marks will have 60 days to consider appealing to the Court of Appeals.
It's, just thinking about it, originally filed in 2020, right? And so it's moved slowly. There have been half-year periods where nothing has happened on this, as I recall, as we've just tracked it over time. So thank you, Kaylee, for jumping in, jumping into the slow-moving molasses on that one. It's an interesting situation, and everything about it is kind of unique because the reserves program is unique in our region, Metro is unique in the state, these IGAs are unique, and so it's all sort of new territory, fun territory for people who love it, but extremely slow moving. It is late, so the other 2 items. Last month, Clackamas County submitted a planning grant to Metro to do a high level, what they're calling development ready land study. They submitted a $1 million grant to Metro to do this work. This came out of Clackamas County Commission discussions in 2024, different commission, but they still submitted it in 2025. The idea is to study all of the urban reserve areas within Clackamas County, because there's others than just Stafford, and understand their ability to accommodate development. This kind of work has been done before, but Clackamas County Commission discussed the current challenges of providing land for housing in Oregon, and they wanted to be part of the discussion, essentially. What lands do we have? How might Clackamas County new areas contribute to the housing, to solving the housing crisis? At the staff level, we had some concerns about this. The West Lynn City Council, the other city councils, Clackamas County itself have these IGAs that we could not see with their early drafts how this grant didn't violate the IGA that we were all a party to. And we expressed that concern. The Clackamas County staff amended the application. The current application, which I can provide, it seems much less in conflict, and we've indicated that. They are taking the study to be very, very, very high level, and they've added a component where only a couple of areas will be studied, and we would hope that the Stafford areas would not be studied. Now, I should say before I move on, our positions on this have been based on previous West Lynn Council positions that prior planning for the Stafford Basin is not a priority of yours or an interest of yours. Obviously, at any time, if that changes, you let us know. Let me know tonight. Let me know and Kaylee know that you want to have a discussion and maybe change the policy. But it's been a pretty long-held belief in West Lynn that we don't have a lot of interest in doing that work right now. The only reason that you would want to do the work is if other people start doing it and we get left out of the party. And that's been discussed many times. But right now you have a pretty solid agreement between Tualatin, Lake Oswego, and West Lynn that this is not a priority, that there's many other things happening right now. So our intention is to keep you apprised of what happens, but there is a grant application being considered right now. If West Lynn Council would like to take a formal position on it, we could add that to a future agenda and you could talk about it some more. We think, the city attorneys have also looked at it, we think that the current version of the grant probably doesn't violate the intergovernmental agreements any longer because the planning is such high level, and without a willing city partner, they probably won't look at doing any of the planning work in the Stafford area. Which is why the third item, Senate Bill 592, probably exists because the cities are unwilling to cooperate in planning and some of the property owners are frustrated. Senator Meek has introduced a bill that would require the state to study the formation of a new city in the Stafford Basin. This is clearly, to me, a shot across the bow. Hey, things are happening and you guys either play or you don't play or you get left behind. That's probably not how Senator Meek would describe it, and I apologize if he's watching that. But I think what we understand is that Senator Meek sees this as a tool to explore how Stafford could address partly Oregon's housing crisis. And I understand the need for looking at housing. We certainly do. We're doing a lot of things to participate to solving that need. I'm not sure a new city is the best way to approach that. And I think all the cities have probably a concern about that. I know our partners in Lake Oswego and Tualatin are not excited about this bill. We assume it's intended to start a conversation. So that is what we know about what's happening in Stafford. It is late, and if you would like more discussion of any of these, we can certainly add them to a future agenda, or perhaps this has been enough.
Questions, sir? So just wanted to make sure we got an update and that topic was on the radar. Of course, if anybody has individual questions about the IGAs or the background, you can always, as the city attorney said, meet with her or meet with John. Or we can even schedule a further meeting. Open the floor up to council for questions or comments, or we can move on to city manager report. I will tell you that when that bill dropped, I heard from the mayor of Lake Oswego immediately, Senate Bill 592, and texting the mayor of West Linn and mayor of Tualatin. So they were definitely talking about that and concerned about it when it dropped. So we'll see where that goes.
Perfect. And I guess my main message really would be we would need to know if this council had an interest in talking about planning of the Stafford area. I would caution you to involve the community in the discussion before deciding to do that, because people have some very strongly held feelings. But also, I don't want to presume. If there's a more nuanced position that we would like to take over time, we are happy to talk more about that and talk about this issue. So we can bring that back. Would you like me to, oh, sorry.
Oh, yeah, I mean, I'd like to hear a little more about the potential and the risks without committing to any kind of decisions. So yes, I accept your invitation to come and talk to you.
Perfect. Happy to do that.
Councilor Bonington, go ahead.
I also think it's perfectly fine to talk about things and be prepared for them. We don't want to necessarily be in the position of hammering the first nail in that sort of development, so to speak. But I think we want to be in a position to not be completely left behind if things start happening. I think we need to be able to pivot to that if that's something that starts to take place. So yeah, I'd like to talk more about it.
Councilor Bright.
I'm just thinking the last incorporated city in Oregon was Damascus, and that didn't work out so well for them. They ended up disincorporating, and it was also kind of, I mean, it wasn't a Stafford, but it was rural community. So
yep.
I'm not sure that a Senate bill is the way to go about incorporating a new city.
DLCD can study our IGAs.
I think they have been doing that actually back in the Marks case.
Well, I thank you everybody for your thoughtful comments, and I don't know if it's something that we'll put on an agenda in the future, just have some individual conversations about before deciding to do that. But I definitely think that there are some, it's an issue to be thoughtful about with regard to Stafford. It's controversial and there's many different perspectives, and it's been something that's been on the radar of the cities for a long time. There's a lot of history that I didn't even know till I got on the city council and started learning. And some of the first folks to reach out were the Stafford Hamlet, and they invited us for a tour out there and stuff. So there are lots of groups interested Council President Baumgartner, I think you're our Stafford Hamlet liaison, so please close us out. if-
Thanks.
Yes.
Thank you, Mayor. Yes, I just wanted to point out that here Westland is now poised to do some long-range planning and hopefully not terribly long with our waterfront and Highway 43 that promise some density. And so it's the first move on density planning that the city has done in, I don't know how long. So maybe we could talk to Senator Meek about that and share some of our, what we've got planned, and that Westland's not just sleepy and sitting around thinking, you know, well, we don't have to contribute to this housing because we are doing something. So, and I do value the rural and potential agricultural uses that are kept closer so we can have local food. And I think the community in the hamlet has done a great job to advocate for themselves, and I listen to them. So
I would hate to lose the wineries.
There's also some farms out there too that are nice. Well, thank you, everybody. With that, we will thank you for the update and the work getting all that together. We'll proceed to the city manager report.
Okay.
I heard there was a wonderful retreat that happened.
Yes, we did have a fantastic department head retreat. Included conversation about the council goals, which seemed like they were going to be adopted. So we started working on how we were going to deliver you some work product on those council goals. Also looked ahead to the budget process as we continue to work at the department level, putting together the budget, and then some internal topics, all of which are actually related to the goals you just adopted for me. As I love to say with a semi-smile, when you adopt goals for me, they become goals for other people too. So it is fun to pass those things down. Really quickly, because it is 9 o'clock and we don't like to go past 9 if we don't have to. You have a special meeting next Tuesday. Don't forget, President's Day. City's operations are, City Hall is closed. For President's Day, the meeting is Tuesday night. You'll have the Youth Advisory Council here talking about traffic safety, and you have a work session with the Planning Commission to talk about housing production. Strangely enough, housing production, because Westland is doing a lot on that. And then probably the main event for most folks is council has requested a sort of open house style discussion about Oppenlander and next steps there. This will be an opportunity for members of the community to come in and talk to council and for council to talk to each other about what we would like to do moving forward with Oppenlander. And so we welcome everyone to show up at that meeting after the main business is done at 7. Yes, is what we're suggesting. 7 o'clock is probably about when that part of it will start. So the next meeting after that, we have the three regular meetings in March. Still working on figuring out agendas for those meetings, although you created some content for those tonight. So we will be talking to you more about items for that. It's a little too early for me to be talking about the Heron Watch at Maddox Woods, but prepare yourself because herring watching does start week after next, I think, is the first event.
can I add something on to that?
Of course.
If anybody wants to look up, there was a segment on Oregon Field Guide on Thursday, and I don't think they ever said this is Maddox Woods in Westland, but it was Mike Hauk, who is, for any birder in the Portland area, very famous birding person, and Audubon, now Bird Alliance of Oregon, longtime leadership member, and he did a presentation about our herons, basically. So
I have found in my travels that many people in Westland have never been to Maddox Woods, don't know how to find it. It's a hidden treasure. And the heron season is really pretty awesome. It's a pretty unique thing to be able to, for many of us, to just be able to walk from our house and see that. So I would encourage everyone to go.
You're going to blow the secret. Stop talking about Maddox Woods.
I love blowing secrets about Westland.
Yeah, but it is one of the best parks, I think. It's great.
Yeah, it's really cool. Well, so thank you for everything tonight, and hope you have a great long weekend.
Else for the good of the order, from council or staff. Thank you, everybody, for the good evening tonight, and a lot of business got done, and we're going to continue to get things done at the city. We're adjourned. Thank you. Oh, that's